What's good, y'all? So, this was in response to my motion to dismiss because my client was being sued by a company that purchased the debt and they filed a lawsuit. She owed $17,000. I filed a motion to dismiss knowing that it was premature, knowing that it may get denied at this stage because if you look right here, judge's response. But what most people don't understand is that I have top elite court litigation skills. So I really filed this motion to set a trap. So I was ordered to respond. So you can imagine that, well, if they denied your motion to dismiss and everything in this response was the same thing I filed in my motion to dismiss. See, I set a trap not only for the company, but for the judge too, because I know court strategy and how to structure a motion where the judge is basically can't even rule against me. Now, most people would say, well, if you filed the same things, double down on your position in your actual response, then to your motion to dismiss, there's no way that the case is going to move to pretrial or a conference. They're going to get awarded. Because you didn't win your motion to dismiss, right? But like I said, I set a trap. Now, look at the yellow highlighted. You see? I pretty much handicapped the judge and not giving them a judgment right at the beginning because they wanted a judgment. But what I did with the motion to dismiss, I laid the trap and then I came back with the response that pretty much handicapped the judge. Now it's our turn. Now we're about to move for summary judgment. And this is going to be another victory. New culture. According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
The new culture empire, where we set standards, raise the bar, and executing greatness right in front of the low-hanging fruit. Poverty mindset's face. Thomas' legacy as Pro C is on legendary status. And if you ain't know, it's the new culture empire.
Bring that one back from the top. Rockin' with the best.
What is the word? The new culture empire.
You're rocking with the best.
We are back in the building with another one. Of course, y'all could probably hear I don't sound too up to par like my normal self, but we are nevertheless, we are here and in the building. We just completed part 4 of the real master netting set off in administrative claims. And that was the last webinar series that we will have until the university actually takes place starting February. Now, Ali, what's up, broski? So, we completed 4 stages of the accounting, not what you see online. You're talking about balance sheet level. For these transactions, the class members discovered from a legal standpoint the discrepancies between the contractual amounts owed versus the amounts booked. They learned what it actually takes to argue a foreclosure from a legal standpoint. And here's the kicker. We read court cases that supported my teachings and claims where the judges were saying the same thing when I try to tell people there's only one way to win a mortgage or argue it correctly. There's only one way to do it. And of course, you know, people online, y'all know that if it doesn't comport with their belief systems, they're going to automatically, you know, disregard it. But we read multiple cases where all the judges were confirming what I teach, especially when it deals with mortgages.
You're rocking with the best.
So those individuals, shout out to y'all for being in those classes and taking advantage and increasing your understanding. Shout out to y'all. Now, the actual registration for the set U, as you can look at the top right of your screen, the actual registration is open. ThomasLegacy603@gmail.com. And once again, everything that's going to be taught in this 90-day university semester, the flagship, is going to be strictly from a professional level. This is not going to be a class where we try to convince you or try to appeal to your belief system. I would advise for the people that's going to join this webinar to at least have a somewhat background in accounting, somewhat background in litigation, or at least a legal interpretation of it. I'm going to be 100% honest. If you believe anything that's remotely close to common law courts, maritime law, putting UCC ones in, if you anything that's remotely close to those things, I will encourage you to please don't join the university. I'm not saying it because I don't want you there. Only reason why I'm saying it, because that university is going to be taught at a set standard. It's going to be taught at a set standard, ladies and gentlemen. And I don't want to waste your time or my time. And it's going to be taught strictly from a professional corporate level. It's the literature, the homework, the doc, everything's going to be from a corporate professional level. It's not going to be belief systems. It's not going to be what I believe it is. I believe which way you should go. Everything is going to be supported by authoritative court cases, judges, college professors, law reviews, regulatory agencies. Everything is going to be supported by factual black and white evidence, and then it's going to be supported by case laws where if you do it the way I say you should do it, you're going to see cases where wins always took place. Here's an indicator. 2026, starting this week, I have 4 summary judgment motions that I'm putting together. Summary judgment motions. When do you ever see pro se litigants move for summary judgment? Okay, so that means outside of my case, my clients, they were all the defendants. A complaint was filed against them. The debt was attached to it. They were ordered to respond. They reached out for my services. I responded on their behalf. The other side didn't move for summary judgment. They remained quiet. Every case went to civil pretrial. Now, when it goes to civil pretrial, that is a very pivotal part of the stage of the proceedings, because it shows that although they filed the complaint, although they passed the threshold of standing in that sense, Even with the debt, they still didn't get the judgment. And tomorrow, a group member has a contested call hearing in their mortgage case. There has not been no judgments granted on the pleadings. But if you look around the landscape, you'll see a lot of these gurus, they always got to file some type of appeal. So we're moving for summary judgment in debt buyer case, auto case. Actually, in my auto case, I'm moving for an entry of default because they didn't even respond or show up or plead. And in the mortgage case, every other case besides mine, we're moving for summary judgment. The only way we can get to summary judgment is if the court has to schedule a civil pretrial. These are pretrial motions. Like this is when they set deadlines for discovery, deadlines for this. Oh, forgot another case. In the state case, we're moving for a motion to dismiss the warrant in debt. I'm putting those documents together this week as well. So we are hitting 2026 with we're hitting it guns blazing, metaphorically speaking. So today we have, and shout out to Mr. Sovereign Encounters. Shout out to him. His link is in the description. He has a lot of good videos. I didn't re-edit it to block him out. His commentary is not that bad. It's not too annoying for me. So today we're going to do pro se defendants live reviews. And I'm going to stop and give my commentary. And we're just going to see how it goes. So without further ado, let's get to it, y'all.
Was also legal encounters. All right, today we're going to be at Judge Hayward Court, where we have a pro se defendant who wants to dispute the debt. Now, we normally know the normal excuses and things that they want to use to dispute their debt. Well, let's see how it goes in this one. Let's go.
Wells Fargo Bank versus Ilan Bomani. Wells Fargo Bank versus Ilan Bomani.
Hello, Your Honor. This is Price Maharaj for the plaintiff on that matter.
All right. I'm sorry. Who is it? Oh, Mr. Thank you. I'm trying to pin everybody as I hear them. That makes it a little easier to see who's talking.
1 second. Hey, do y'all want me to turn the vertical off? The one, what's up, homeboy? Do y'all want me to turn the vertical off? Do y'all like it better? Let me see. High vertical. Do y'all like it better like that? Put a one in the chat if you want it better, if you like it better like that, or do you want the vertical as well? Because I know some people like it, some people don't. If you want it to remain like this, let me know. Or if you want it like this, the vertical as well, y'all let me know. Yeah, I do sound a little better from yesterday. Yeah, yesterday I had to get through that. It was dragging. So do y'all want the do y'all like it better like this? Hide the vertical, or do y'all want the vertical show? Y'all let me know. Just, hey, if y'all want it, if the majority, if y'all want it just like this, just let me know in the chat. If this is cool this way, we'll just keep it that way. So let's get back to it.
All right, and Ms. Bomani, I see.
Yes, I'm right here, Ilan Bomani.
Yes, ma'am. All right, Ms. Bomani, do you have somebody representing you, or are you representing yourself?
I'm representing myself today, Your Honor.
The mistake has already begun.
All right, so
yes, I do agree. You don't want to step in these courts and represent yourselves unless you fully understand the court rules and procedure. I swear they are so technical.
all right, so this is a contract with respect to what appears to be like a credit card or some kind of credit account. Is that correct, sir?
Yes, Your Honor.
Okay, and the defendant was personally served and answered, filed a counterclaim.
The answer does say counterclaim. However, I've got it pulled up right in front of me. I had a chance to review it, and I don't see really where any claims against our client have been made.
Yeah, I think that was that she was seeking information that she says wasn't provided. But I don't know that it was a counterclaim in the true sense.
Yeah, that's what I was getting at.
Okay, so go ahead, sir, and present on behalf of your client. And is your client the original creditor?
Yes, Your Honor.
Okay, so we have original creditor. So there's not going to be any chain of assignments, chain of title. And guess what? Those are a lot of defenses that I see. But here's another thing you got to be cognizant of. What are you going to do when you're dealing with the original creditor? Because that chain of title, chain of assignment, that's not even a legal argument anymore because they are the original creditor. So where's the legal defense? Where's it going to come next now? Because a lot of people load up on that chain of title, chain of assignment argument. But when you're dealing with the original creditor, it seems like a lot of people, they don't know what to do next. That's why I say when you study, you got to study for multiple scenarios. You got to be able to anticipate whether whether the debt was sold or it's the original creditor, because you have to have a defense for the original creditor. Get the likes, hit the share, share, like the comments up, y'all.
Okay, so ma'am, this Mr. I'm sorry, Mr. Maharaj.
Yes, Your Honor. You got it.
Mr. Maharaj represents the original creditor, Wells Fargo. And go ahead, sir, and present.
Yes, Your Honor. If it may please the court, yes, this is I will be brief on this one, Your Honor.
When you're in court, when they say, hey, we'll hear from you, please start your sentences off. Yes, Your Honor, if it may please the court. That is a legal custom. If it may please the court. It shows you understand the courts. It shows professionalism, and that is a custom amongst all lawyers. If it may please the court.
This is a lawsuit brought over a consumer credit card agreement entered into between Wells Fargo Bank and Elon Bomani. The facts of this case are fairly simple, as stated in our motion.
Do you have what they're seeking? What was owed?
I'm sorry, say that again, Your Honor.
Do you have what was owed? What are you seeking?
Yeah, we are seeking principal amount of $16,217.20.
Damn.
Court costs of $307.11. And this particular client, when it comes to collecting attorney's fees, they ask that they don't collect any attorney's fees over if it turns out to be over $800 or more, they don't collect more than $800. So in this particular case, the actual motion says attorney fees of 15% of the first 500 and 10% of the remaining balance. If that turns out to be over $800, the client has asked that it be capped at $800.
Okay, I got it. No problem. All right. So, Ms. Bomani, my review of the information shows that there's not really a cognizable defense, in that there's no defense that you do not owe the debt. And the counterclaim seems to be that you were seeking documents.
Yes.
Okay.
The affirmative, the response, the affirmative defense is that the plaintiff did not provide documents showing a contract between the defendant and Wells Fargo Bank.
See, this is exactly what I mean. You cannot use there's no contract as an affirmative defense because you've already swiped the card. And this is, I don't know if people don't read their credit card agreements because they're so excited that they just call and activate the card and sign the back of the card and start swiping. It is a known statement on any credit card agreement. Once you swipe the card, you have agreed to the terms. There doesn't necessarily have to be a written, like, specific contract. They mail you the credit card agreement with the card, and the deal is memorialized once you swipe it. If you don't agree to the terms, you have to send the card back, and that's how it goes. What she should have done, instead of trying to argue there was no contract, she should have disputed the balance owed, the amounts owed. Is Wells Fargo's really, have an interest in this, the original creditors? So you'll have to come up with hell of a arguments to dispute that. But when you're dealing with the original creditor, you got to get deep into the corporate legal lawyer side to put up a defense, because there's no chain of title, real party of interest arguments there. But she already started off wrong looking for a contract because you've already swiped the card. So that argument is dead on arrival.
With the defendant's wet signature.
It's funny in these.
Once again, what do I always say? It's going to be some wet ink signature, when today they don't need to produce the wet ink signature because we are in electronic times. Like, they didn't ship a pen with you to sign and then you send it back. Ladies and gentlemen, if you're listening, you're going to be watching this live later on. You are only hurting your chances of succeeding when you request the wet ink signature, when every contract is going to be held in electronic files. It's called authoritative electronic copy. That's good enough, and it's going to hold up in court. There's no requirement for a wet ink signature because we're not in year 1908 anymore.
Cases that when they use the credit card, there's no contract, no signature. But as soon as money's being asked to repay the credit card, they're looking for a contract and a signature.
The second one, the plaintiff has not provided any documents authorizing the handling of the defendant's personal data. This is all information I requested. Number 3, the plaintiff has not provided a complete account number for defendant to review for the alleged debt. Number 4, the plaintiff has not provided a full accounting of alleged debt for the amount of $16,217.20. Account numbers unknown. Defendant requests to review all original creditors, payments, credits, interest rates, disputes, including a signature or digital PIN code approving alleged charges claimed. Number 5, plaintiff has not provided any documentation showing the debt is 100% accurate with no errors or omissions.
All those claims are it's just useless. It's just worthless. They're worthless. She should have just said, I don't owe this debt. She should have just said, I dispute every allegation. I don't owe the debt. All these extra things that she's asking for is actually going to counter against her. It's hurting her chances. Just say, I don't know what the hell you talking about. I don't owe this debt. Then it gets to the stage where you got to start proving. But then if you don't know how to attack them from the accounting side, then they're going to produce the regular general statement. And if you don't know how to attack it, and you can't just say, oh, that's not me, I ain't spend that. If you don't know how to attack it, the courts are going to uphold it.
Number 6, the plaintiff has not provided communication between the plaintiff and the defendant. Number 7, the original creditor has possibly filed a 1099-C collections of debt with the IRS. This would void any ability to collect on any alleged debt. Defendant requests proof Wells Fargo Bank have not filed a 1099-C collections of debt write-off to the IRS.
Okay, so a 1099-C, it only means to the IRS for federal tax purposes, you're mixing consumer law and debt with tax law. Once again, when you get a 1099-C, it means that they have no expectations of you paying the debt. So you get a 1099-C. It's basically income to you now, how the IRS looks at it. Now you must report the amounts on the 1099-C as income unless you can prove to the IRS that you were insolvent at the time that the 1099-C was issued, and yes, they have a direct form for that. You file that form along with the 1099-C, and in many cases, you're getting a 1099-C anyway, so obviously you can't pay the debt or refuse to pay the debt. So then you won't be taxed on that income. You're getting a 1099-C in a nutshell as income to you. It's treated as income to you, and you may or may not be liable for the taxes depending on the amount. $16,000, you're going to be liable for some taxes on that. So she needs to file the insolvency form. There's a direct form for that, so she won't be liable for the taxes. But a 1099-C in a tax context does not mean you still don't owe the debt. Like, they can still do that. And I don't think they filed a 1099-C, and they only filed 1099-Cs around tax time. So depending on the time of this proceeding, she wouldn't get a 1099-C anyway.
Number 8, the plaintiff did not provide a dunning letter giving defendant the opportunity to dispute alleged debt. Number 9, the plaintiff has excessively delayed in bringing this lawsuit to my disadvantage due to non-availability of communication and document requests, being cut off with the original creditor to establish concrete proof of the claim amount by the plaintiff. Number 10, the plaintiff attorney, I don't want to mispronounce your name, sir, so excuse me if I do, Paresh Maharaj of Lefkoff, Rubin, Gleason, Russo, and Smith, PC, is a debt collector, has a requirement according to the Fair Debt Collections Practice Act to notify defendant by mail with a dunning letter, giving the defendant the opportunity to dispute alleged debt. Number 11, the plaintiff attorney, I've already spoke of their names, is a debt collector and has requirements according to the Fair Debt Collection Practice Act, 15 U.S.C. 1692G, to review and provide documentation to show proof of alleged debt and how plaintiff provided proof of how the alleged debt was accumulated with true accounting records and statements.
Yo, 1 out of every 100 person that cites 15 U.S.C. 1692G ever cites it correctly. It's all misinterpreted. I guarantee you her misinterpretation of that statute is led her to believe that they didn't follow the statute. What I believe from what I'm hearing from her is they did give her the required documents under the law. She just didn't understand the statute enough to confirm. So she probably believed they didn't do it. But I guarantee you they provided something to her that satisfies the law. Because one thing about attorneys that I know, they went to school to understand rules and procedure, and they rarely ever break them. And when they do break them, they get away with it because pro se litigants don't know the rules and procedure to spot out when they're not following them.
Now, I'm showing this on the screen because some people will hear her say the 15 USC and think it's automatically a sovereign citizen argument.
No, it's not a sovereign citizen argument. It's a very legit statute. It's a very consumer debt statute. So it's the amount of debt, the name of the creditor to who owes the debt. So the amount of debt, $16,000, right? And some change. Name of the creditor to whom the debt is owed. It's already established. It's Wells Fargo, the original creditor. A statement that the consumer has 30 days to dispute the debt. I guarantee you that they probably sent that letter to her. Number 4, a statement that if the consumer disputes the debt, the collector must obtain verification. Once again, we'll see it play, but I'm assuming that they sent that to her. Number 5, a statement that if requested, the collector must provide the name and address of the original creditor. Once again, Wells Fargo is the original creditor. So 1, 2, 3, and 5, I'm pretty sure she already received that. 3 and 4, I'm going to assume that she did, but we'll see how it plays out.
What she's talking about is something that has something in relation to debt, as she did read. So I just wanted to highlight that part in case somebody had misconceptions about the sovereign citizen argument versus the pro se argument.
Now listen, y'all, sovereign citizens, they do cite legitimate consumer law statutes. They just cite them incorrectly.
And last, number 12, the plaintiff attorney is a debt collector, has a requirement according to the Fair Debt Collection Practice Act, 15 USC 1692G, to provide a proper validation of debt within 5 days of initial contact. Because plaintiff attorney never provided a dunning letter to the defendant, plaintiff attorney did not comply with the FDCPA requirements, 15 USC 1692G. Defendant reserves the right to amend his answer after receipt of additional documentation from the plaintiff. And this is what I had requested.
All right, Mr. Maharaj, you want to respond to any of that?
And if you look at the look on the judge's face, the judge already knows none of it's because she has the court files. The judge already knows, lady, you lost. But we have to give you a due process and we got to let it go. Everybody in the courtroom knows she lost.
Yes, just again, as mentioned in our response to the opposition to motion for summary judgment, I especially want to highlight the claim that plaintiff has not provided a verification of the debt and all of the accusations that the debt has not been properly verified under the Fair Debt Collections Act. Although not required by statute, we did provide verification of the amount owed to the defendant on April 29th, 2025. This verification was mailed to the defendant to an address of 11383 Michelle Way, Hampton, Georgia 30228. This was attached as Exhibit A to our response to the counterclaim. Furthermore, we have judging from the exhibits that we have provided with our original complaint, which includes bank statements and payment histories that have been authenticated by affidavit, we have provided accounting showing the balance owed.
So once again, number 3 and 4. So 1 through 5 has been satisfied per the reading of the statute. I want to see what she has to say now.
So I would just say that we have met our burden to verify this debt, and we have upheld our burdens under the Fair Debt Collection Practices Act, and as such, there is no issue of material fact, and ask that summary judgment be granted.
Hey, every time.
You're rocking with the best.
What did I say? What's the normal occurrence? They file a dispute against the consumer. The consumer responds. They immediately move for summary judgment. I mean, it's becoming so normal that it's like just the normal course of action. That's what separates us from the rest. They file a claim against my clients. We respond. They remain silent. We move for summary judgment. See, with us, it gets reversed. And listen, you have to stop filing these debt validation, debt verification, cease and desist letters. Stop asking them for things that they can provide. Debt validation, debt verification, to me, it's an extension of discovery. We never ask for things. Let me scratch that. We only ask for things that we both know that if they provide it, it's going to prove our case. You don't ask them for anything that they can provide that's going to prove their case. You ask them for things that you know they don't want to or cannot provide you because it's going to hurt them. And this is where the deep dive understanding of accounting and litigation comes into play, so you can actually know what to ask for. All these generic ass requests that I hear people ask every day, blue ink signature, notice me, my social security data, none of that is going to help you.
Ms. Romani, he stated that on April 29, 2025, the quote unquote dunning letter that you requested was sent to the address, that there are bank statements filed with the court that show the progression of payments and their accounting with respect to the amount owed.
I'm sorry. I didn't hear the first part of it?
That the quote unquote dunning letter that you wanted
Yes.
was sent on April 29th of 2025, and that the file file contains the accounting complete with bank records to show any payments made to the account.
That I did not receive that, ma'am.
How did I know that statement would be next?
Did you?
Okay, so yep, sovereign encounters, brother. So basically, like I predicted, she didn't even understand the statute of which she cited. So she believes what she got didn't meet the requirements, when in reality, what she got met the requirements, which only proves the other side's case, because that's all she asked for in her defense. So once they prove it, she still didn't dispute the debt. She still didn't put up a legal defense that she doesn't owe the debt. She didn't give the judge any reasons to set this matter for civil pretrial, meaning, once again, 99% of pro se litigants, once a complaint is filed against them attaching a debt, they can never get past that initial stage.
Look at the clerk's file.
The clerk's file.
And he would have filed it with the court clerk.
Yeah, I did not see that. Not at all. Where shows proof of that? Because even in my defendant motion of opposition to plaintiff for summary judgment, it basically stated that I have not seen that, ma'am.
Okay, Mr. Maharaj, you filed all those things with the clerk of court?
Yes, State Court of Clayton County. This particular one was filed on September 22nd, 2025.
Look at these. Hey, I'm not trying to be prejudicial. I'm not trying to be funny. I swear to God, don't take it out of context. These motherfuckers from these countries, these lawyers, these motherfuckers, they be on everything. They don't let nothing get past them. They don't let shit get past them. Woo! When you see out one of these motherfuckers, the attorney, man, these motherfuckers, boy, they don't let nothing get by them.
That was after.
After what?
After I made the request for it.
See the judge's face? She just going through the motions.
I made the request for it on July 17th of 2025.
Yes, and
in response to your request, he filed it with the court clerk.
Okay, I didn't receive any information in regards to that.
Did you send Ms. Bomani a copy under by post, or did you just electronically file it?
This was electronically filed.
Okay, I'm not sure she. I'm not sure.
Oh, I believe she actually got it. She just didn't. That's what I'm saying. She didn't understand the requirements under the statute, so she's looking for something else. So, and this goes to the mindset. She's looking at 15 USC 1692G as if they don't provide her exactly what she asked for, then they're in violation of the statute. So they all, once again, what she requested, she thinks that they have to give her all those things unless they're going to be in violation of the statute. When what she requested versus what the statute says they have to give her are two different things. And this is where the disconnect is at.
Sure, if she gets the electronic filings.
I did not.
We also filed a certificate. There was a certificate of service. It was with the same mailing address that we had. 11.
You already didn't block out the address the first time, broski.
Okay, so you did send it separately?
Yes.
All right, so he said he sent what he filed separately to you.
Ma'am, I in all honesty, Judge, Your Honor, I never received it.
In every hearing I cover, they get the credit card, but when it's time to pay back, they never get that piece of mail.
All right,
I'm just now finding out about it today.
Ms. Powell?
Yes, ma'am.
Do you see the documents filed by Mr. Maharaj?
I have seen them. I can pull them up again, but I do specifically remember looking at them and looking at the date of April 29th. It was filed into the record, but it was proof that he had mailed it previously.
Okay. All right, so if you want to put, you can put those up. Miss Powell, let me see the file.
Okay, just give me 1 second.
Your Honor, if it would help, I have it pulled up. I could share my screen.
Yeah, go ahead, Mr. Maharaj.
Okay, is this working?
Yeah, that's fine.
Okay,
Okay,
so
so this is the certificate of service, Miss,
Y'all, he blurred out the screen, so you're not being tricked right now.
Yes,
Bomani.
ma'am.
Okay. Go ahead, sir.
and yes, so as you can see, a plaintiff's motion for summary judgment in response to counterclaim. And this is just to go from beginning. This is the proposed order. Just to this is the first page of the actual motion. As you can see, he filed on that date. Just gonna scroll through just to show everything. And here's
Yeah, no, I did receive that, yes, but I did not see it in compliance with the Dunning.
Well, again, as attached as Exhibit A, here's the letter right here that was mailed on April 29th.
There she go. That was the whole. That's what I assume. She thinks it's not in compliance, so that's why she's saying she didn't get it.
And that's what I was also going to pull up, Judge. There's no that I saw no fuller copy of the letter, but it is verification that the plaintiff or the defendant's requests were responded to.
So, ma'am, this is what you were asking for.
Don't even realize what she was asking for. She got. I don't understand how any.
Okay. All right. Okay, I did receive that.
Okay, so then he did comply with the regulations that you stated.
Okay.
Is there any dispute that you have as to the amount of the debt of $16,207.20?
That was what I said from the beginning. She was better off just saying, I don't owe that shit. Now, that may, depending on the facts and circumstances, get you to the next stage, but then you still going to be at a point where you got to legally argue that you don't owe the debt anymore, or they don't have the legal authority to collect from a legal standpoint, not your beliefs, from a legal standpoint. Now it gets to that stage. So that may buy you some time. And I think that's what she should have did for real, 16,000. Ain't like she owed 800. So, man, it's sad, man.
Yes, ma'am. Like I mentioned to you,
just say, I don't owe this. I'm out. Just say that. Don't say nothing else.
In my defendant motion in opposition to plaintiff's motion for summary judgment, the key thing that I requested was that the plaintiff.
Do you have evidence of payments made?
Yes, Your Honor. They are included with the original complaint.
Right there. Why did she ask that question? Because as soon as they show evidence that you made payments on that card, but you never disputed it, never sending claims from the beginning, now that you're getting sued, you're asking for all these things, the courts are going to see right through it. It was in my last video over the summertime. You got to be current, bring the credit card account current, and then you sue. Or you should have sent the card back. Man, I'm trying to tell you.
It labeled as exhibits A, B, and C. I could also pull those up. Oh, would you like me to pull those up?
You may. Ms. Bomani, do your records differ from the records Mr. Maharaj is presenting?
The key thing that I wanted to establish was that the plaintiff motion, it's vague. It's not conclusive.
Ma'am, stop it. Just stop it.
It's not including all the other information that I had requested.
So, okay. Do you have any information that says you made payments that weren't taken into account?
No, ma'am.
Okay, then that's what I'm asking. So at this point, the court is going to grant the amount of $16,217.20 plus $307 in court costs, $307.11 in court costs, plus $800 in attorney's fees as capped by the contract.
And this is why you should join the Supreme Elite Team University, because you are going to learn how to legally dispute this stuff. This is crazy, man.
All right, Mr. Mirage, you've presented a proposed order. The court will get that signed. Ms. Bomani will get you a copy of the proposed judgment. I mean, of the judgment, and then you, if you wish to speak with Mr. Mirage, to, I guess, request a payment plan with his client, I'm sure he'd be willing to talk to you about that.
Honestly, we have a negotiations team. I could have them reach out to you. Is your email address, Ms. Bomani, still Elon?
Yes.
And phone number is still 47?
All right, y'all. That's the, as you can see, that run right there was
Welcome to Sovereign Citizen Legal Accountants. All right, today we have a sovereign citizen that's in the landlord-tenant dispute. But the paperwork and the arguments they want to bring, it's going to be a little bit different, and I'm sure it's going to be very entertaining. So let's go in and check this out. Let's go.
So we are here on an eviction.
Yes, sir.
Okay.
Correct.
All right. You don't have
judges at the top. Judges at the top, y'all. That's the top right. Probably y'all left.
to stand up. This isn't, yeah, y'all can sit. This is JP court, not federal court, but I know in federal court is a lot different.
Yes, it is. Everything is serious in federal. You walk through the courtroom, everybody, the marshal series, the judge sitting with you. You ever been inside a federal courtroom? You know it's serious in that courtroom. Good. And you, oh my gosh.
So everyone can sit and go ahead, sir. So this is an eviction, and I don't know if you had an opportunity to kind of review any of this stuff that Ms. Clark filed today.
I have not, Your Honor. I'm starting to kind of browse through it right now.
Okay, go ahead, and I'll give you a minute to do that because it's quite lengthy. And just to give you a little background, we were here back on August the 19th. And I did dismiss a counterclaim because in an eviction case, there's no counterclaim. So I dismissed that for lack of jurisdiction because there's no counterclaim on an eviction. Then we reset it for 2 weeks, I believe, for plaintiff to prove that they're registered with the Secretary of State.
Which they're not.
Well, I'm just giving him the rundown.
Yes, sir.
Okay. That they're registered with the Secretary of State. And then on September the 2nd, we were here and we abated it 60 days. And then we came back on December 9th and reset for 1 week. And that's how we're here. So just to let you know the background of the case.
Okay.
So, all right. So you filed some things today. So
all right, y'all, we about to get into it. Let's break it down. This is a landlord tenant case. Let's break it down.
Do you want to, I don't know who should start first on this one. Go ahead, since you filed today. Yes, ma'am.
Yes, so on August 19th,
Yeah, I think she's actually in the courtroom. Yeah, so all right, the left, top left, that's where it's at. So they're not anywhere on the bottom screen. They're on the top left.
provided facts and evidence that the plaintiff did not have standing. They were not registered with the Secretary of State. She did claim that she was registered with the city. However, I did do a follow-up with the city, a Public of Information Act request, and got copies, which I'd like to enter into evidence, that they are not in fact registered with the city.
Uh-oh. Uh-oh. Uh-oh.
Is this something that you filed? Are these some exhibits or this is an addition?
It's in the exhibits.
Okay. Is exhibit what? I'm so sorry. You have so much here that I don't
know where to find it?
Yeah.
I don't see that specific exhibit.
Y'all, please make sure everything is labeled Exhibit A, Exhibit B, Exhibit 1. Like, don't make it, because they don't have time to sift through all that in court. You gotta get straight to it.
Oh, I do see Exhibit E.
Yeah.
There
Okay,
you go.
you can give that. Thank you so much. So
Okay.
it's Exhibit E.
Then after the 2-week mark, you had asked her if she had gotten registered with the Secretary of State. She claimed she did. I have facts and evidence from the Secretary of State that they are not, in fact, registered with the state still.
And that's Exhibit G.
Yes.
Okay, that's okay. I think he has all of the exhibits. That's Exhibit G that she's referring to. Okay.
I brought to your attention that the corporation that's on the deed and deed of trust is not the same as the corporation filing suits. I did get a certified copy from the Secretary of State showing that the corporation that's on the deed and deed of trust does not have any DBAs or certificate of assumed names.
Let me see what that is. I'm trying to figure out what exhibit that is. That is Exhibit J.
So I think what it appears that she's trying to bring, I think she's saying the real party of interest. So the party that's on the deed of trust is not the party bringing suit. That is a good argument. It's a good argument. So far, she's surprising me. So far.
Okay.
I also brought to your attention that I do not have a lease agreement or a valid maritime contract.
God damn it. As you're taking one side for it. Now, God damn it. As soon as I gave her the goddamn credit, what the hell did she do? He messes it up with the maritime. Damn it, girl. Got to be more careful.
Is she living on the water?
With said corporation. I did inform you that the Converse Meadows FMHC LLC, who I did have a contract with, a lease agreement, was void, null and void, because they were dissolved for cause by the Secretary of State for failure to pay state taxes, March 10th of 2023.
Okay.
And I submitted in an exhibit, my lease agreement that is not with the said plaintiff.
She's trying to bounce back.
Okay. Exhibit B.
I also entered into the records on the ledger that they have the name of the plaintiff is not on the ledger. That would be Exhibit A.
Okay.
I also, on Exhibit C, I printed out multiple maps, one from the Bear County Appraisal District map that shows that the roads are CD. Picture of my home and the street name, which is Street. I also did a Google Maps and Apple Maps of me in my home, and I entered the address 76, and it takes me to different locations.
Yeah, I'm still trying to find the punch. I'm still trying to figure out where she's going with this.
And then Exhibit F is where I informed you that I had filed a notice of removal from the state court to federal court.
That's what you just filed this morning.
Yes.
Okay.
And it was relayed that I did not file it, but here's the exhibit, and I circled down here where it was filed with the state.
In August. August 29th. It looks like it was filed.
Yes, August 29th.
Okay.
And so therefore, the plaintiff does not have standing.
Uh-oh.
They are not registered within the state. And under the Texas Business Organization Code, again, Title I, Chapter 9, Subchapter A, Section 9.051, an entity cannot file action or suit in this state if not registered with the Secretary of State.
Uh-oh. Okay. Pretty, hey, besides that maritime, I mean, she don't know where it's going to go, but I give her kudos for at least putting up somewhat of a coherent argument.
Okay.
So I am asked, my wish is for this case to be dismissed with prejudice in my favor. I don't have a lease agreement. There's no valid
Right. You keep saying the maritime contract. Stop saying that. You're not on the ocean.
The contract that I had with the old corporation is dissolved for failure to pay state taxes, so it's null and void.
I wonder if she had a maritime contract with them.
During the time of we were supposed to have mediation, I reached out to Jasmine Uphoff and I asked her about it, and she made the statement that she was waiting to hear back from the courts.
I wonder if she took into account, what if the companies that's suing purchase or acquire the debt? Did she ever account for that? She didn't bring that up. I hope she realized or did some research to see if they actually just acquired it from them. Because if they did, everything she just said is null and void.
I don't know what she meant by that statement.
So y'all never went to mediation, or
I never went, and I approached her about mediation,
Okay.
and all she could say is, "I'm waiting to hear from the courts."
Okay. I don't know what that means either. So, okay. All right. Anything else? You can have a seat. Anything else, Ms. Clark?
Yes, under the Texas Rules of Civil Procedure, Rule 21 and 21A, the filing should be served on all parties of an attorney representing them. I never received any certificate of service. I know y'all just did it now today in the courtroom.
Understand.
But it also says under Rule 8, attorney in charge requires that when a party is represented, the attorney must be designated in the first filed pleading and must sign filings. Rule 57, signature of attorney. A pleading is not considered filed by an attorney unless it bears their signature. This piece of paper is not a pleading, and it's not a notice really of appearance. It's just a piece of paper with writing on it.
Hey, she's pretty good. I mean, it's as good as I've seen in a long time. Come on, y'all, let's get them likes up, man. Let's get them likes up. We had 18, almost 20 people in the building. Come, let's get them likes up. Like, share, subscribe. Let's get to it.
Anything else? Okay. All right. Yes, sir.
So, Your Honor, it's a simple case. There hasn't been any rent paid for over 10 months now.
10 months, no rent?
We have not filed an updated amount.
Okay, so bam. So I already knew they was going to counter with that. When you're in a landlord-tenant case, yes, she made arguments that probably affected their standing, but the core issues in a landlord-tenant case, eviction case is, did you pay or did you not pay? And how much time you're probably going to need to get caught up. That's really the core issues of these courts. She put on a good cause. I get where she was going with it, but the core issues still comes down to, did you pay or did you not pay?
But I think it was about $625 over 7 months. So it's actually more than that, but that's just the amount. The $4,340 is what we're here for today. Also possession. So a couple things. I am David Compa, and Art Martinez Zavara is here as well. We're here representing the plaintiff in this case.
One thing, I don't mean to keep cutting up. One thing about this, and this is one of the fatal errors that she made that I'm seeing right now. With all those evidence that she had, She should have never waited till she was getting sued to bring it up. She should have came in as the plaintiff while she was current, and she probably would have won. Real live.
To take care of any sort of issue, we're making an oral appearance right now. We've also given something written over to the court as well. That was handwritten, and copies were made of that to make our appearance here today. The federal case was remanded back because there was no basis for it. And that was remanded back in just recently, November 5th, it looks like. And I have the
Hold on, lady. You knew the case was remanded back. Why did you even bring it up in court? Well, I should have known, because she's kept on with her arguments, because if it was still pending in federal court, all state actions must be ceased, must be put on pause. So I should have known that. But lady, why would you even bring that up anyway? If you knew it got remanded. You see what I'm saying? Yeah, they'd be so quick just to talk and get everything on the record. Some things you could put on the record and talk yourself right into a loss. You should have stayed away from it. It doesn't help you.
docket control order here are all the items from the federal court. And this is the order as well, remanding everything back to the JP court.
Yes, can you?
Oh, sure.
Sure. Received anything from the JP court?
No, it's for you to look at so I can give the judge.
Oh, you didn't even know. Oh God. Y'all, it's fastly unraveling at the seams.
It has to do with the federal court, not the JP court. Correct?
So that's correct, Your Honor. So jurisdiction is returning back here.
Yes.
Just want to make that clear that it's not still sitting over there. So anything that this court rules on is not going to upset the federal case. And that order is there as well.
Well, I'm going to have to object. Again, how am I supposed to quote, pay, close quote, to a corporation that's not registered with the Secretary of State?
You want to know the difference? And these are the harsh realities of courts. You should have came in as the plaintiff. They're the plaintiff. The venue was proper. You didn't pay. You have to come in as the plaintiff with these issues. And you're supposed to sue them in civil court, not landlord-tenant court. When it's I'm going to say it again. When you are in eviction court, the only thing that matters is if you paid or not. Her claims are over civil claims in the general civil division, not landlord-tenant court. Oh, God, it's unraveling fast.
Okay,
sure.
We'll get to that in just a minute, but I'm glad that you gave me this. Is this for our copy or
it is, Your Honor. You can keep that as your copy.
So this is remanded back. All right. So there's no federal case that's open at this time.
That's correct.
All right.
Now, as far as the entity, the old entity did sell this manufactured home area to the new owners.
What did I say? What did I say? What did I say?
You're rocking with the best.
I said, did she account for maybe that they acquired it? See, she's so narrow on them not being licensed. She didn't cover all the bases. And this is what we do at the Supreme Elite Team University. We never get on one track. We are so broad and objective. We cover all possibilities. That would have been one of the first things. Once that felt like the old owner was dissolved and no longer in the picture, and now they're stepping in the picture, the first thing I would have researched is, let me see if they actually purchased the debt, because they can't be that stupid of showing up trying to sue and they have no interest in it at all, just like a random person just stepping in suing. I know they're not that stupid as attorneys, so I would have probably concluded that they are the acquirers of the debt. Now I would have started attacking their transaction, trying to look for anything. But once again, she's in a landlord-tenant case. These cases are very limited to the payment of rent.
Obviously, we don't live in a world that if the property gets sold, you just get to stop paying rent and live there forever.
Obviously,
that's probably what it was, but damn it.
he hasn't seen the Solve Sys script.
All that follows as well. My understanding is you were waiting for a bill of sale on there. This shows the bill of sale. Now, the entities that I have here are Bridge WF2. They have Texas Converse. They have Manufactured Homes. They're subsidiaries of each other. These are actions. One of them is managing the home. The other is the owner of the entity. They've set up different entities there in order to operate business, protect themselves from liability, just like any other entity does.
And when they sold, did they not I guess draft new leases for all the tenants to sign, or?
No, they did not, and that's not required. The leases run with it as well. So just as in, they're not allowed to go in and evict everybody who's there when the property sells. You have to accept it with the lease that runs.
And do you have well, no, she has the lease here.
Yeah, she filed it here. We have some other attachments. These are some community rules that she signed as well that went along with it too. Now I know in the counterclaims, and I guess we're not dealing specifically with the counterclaims, but there's all sorts of claims in this case right now saying that there is there's no valid maritime contract. This is a birthright citizen and a national, other things like that.
Birthright citizen, not a national. You just couldn't stay away from it. I told you, that's sovereign citizen, boy. That it creeps in your soul.
All those are just legal fictions.
Eh?
Everything we're doing here operates under the jurisdiction of this court, this state, the United States, and claims that this person is somebody else. All those are invalid as well. But I think you've already addressed those with the counterclaim. So I'll also
Okay, so it looks like the effective date for the lease agreement was December 1st of 2021. And is that correct? Or is there any other new release, or is that the one that you have as well?
Yes, the lease agreement that I have, that I signed, was November of 2021. On the ledger, it states a different date that I have been there for, which is inaccurate, more discrepancies.
Okay, but you still live there, correct?
Yes, I make that my home.
Okay. And the rent was, let me look at this lease. The rent
was $450.
Okay.
And then when the new said corporation came on, they tried to increase it to $620, which is 28%, which I believe the codes, I don't remember exactly which your code says it can't go above 20%.
Yeah, but in what context? What type of transactions?
and Donna, for
Hold on.
for purposes today, we'll even waive that. We just want possession of this, and so we'd be willing even to waive whatever amount is owed just for possession.
They don't want any money. They definitely want her out of there.
Well, I'm going to object because I own my own home. I'm not renting my home from them. And I have evidence of the payment that I bought my own home.
Whoa.
So wait, is this like a slot that you're renting and you own your own home, but it's on a
piece of
lot?
land.
Yeah, on a lot that you rent from
On
them.
the-
Is that correct? But
Yes.
you own your own home, yes.
I own my own
understand that.
home, so they can't evict me out of my own home.
But they can, we can, since you haven't paid the lot,
They can evict you off the land, so you have to pick up your home and go.
Who
then
am
you
I-
need to move your home
Who am
because you own your
supposed to
home.
pay to? Because this whole time they've had different management. I've gone to management. Each manager gives me a
You notice how now her arguments is changing now? You notice how she didn't double down on her, you see all those arguments she was making in the beginning? You notice how she just quickly abandons it now? Who am I supposed to pay to? Now you've already admitted that you didn't pay. You see how quick, when you really don't have foundation in what you're doing, you're just citing things, see what happens. She didn't stand on none of that. What did she do? Who am I supposed to pay now? Admitting that she owes the debt because there was no foundation in what she was saying.
You're rocking with the best.
A different answer. So there's no full and honest disclosure of who I'm supposed to pay, because I could pay to Converse Meadows, but then how do I know where my money is going to?
So for 10 months, she couldn't figure out who she was supposed to pay?
Furthermore, as previously stated, when my contract, the corporation I had a contract with, when they were dissolved for cause for March 10th of 2023 till December of 2024, where was that money going to?
Well, they're not even asking for any money right now. He just said that they're going to waive all fees. They just want possession of their lot. So,
Well, on the bill of sale, what's actually being sold and what's being bought?
well, it's the park, the trailer park, or I don't know what it's. All the little lots in that area was sold to somebody else. The park units, it says right here, the park units. So it's all those units. I don't know how many there are, but it doesn't matter. You're living there, and it looks like it was sold on May 15th of 2024. Let's see. Sold and conveyed May of 15th. So did everybody get some kind of a letter stating now we've sold it and you need to make your money orders or checks out to this corporation or anything?
Yeah, I know that that's often done. I can't say for sure one way or the other.
Well, that's interesting right there.
But the office and everything has remained. They're still the same location. There's continuity either way. I don't know if there was a specific one to that. But
okay, but there is an office in the trailer park that you can go to make your payment, or what?
I'll have to check with this client to be sure, unless Ms. Kimber knows.
I don't know because I don't have a lease agreement with them.
Because if it gets sold, then where would they send the payment, or
Sure.
what would
And I
happen?
believe it's the same place, but let me just check real quick.
Okay, perfect.
There is an office, Your Honor.
So how would
There is
we
office
know?
there.
I'm sorry.
There is an office there on property. And also, Your Honor, I'll just point out that she's made payments after the date of sale.
Uh-oh.
This didn't all stop. She had been making payments even after that. So there's no disconnect as far as payments and where to go.
Could you tell me what months or when did so she made payments after the May 15th of 2024
That's
sale?
my understanding, Your Honor. We did submit a ledger. Let me just look at that real quick.
Yo, if you made payments after the sale and all that, you just killed all your arguments.
The ledger.
This is where the payments come. This is up to December. So that's her last payment. And then she hasn't made any payments since, but you'll see there's December.
November, December, October. Yeah. Okay. So she's been making it and then she just stopped.
Yes.
Okay. It shows that you were making it.
When I learned about the corporation being dissolved, I didn't know who I was doing business with. I hadn't had a new lease agreement, and this ledger has Bridge Property Management, not Bridge WF 11 or II Manufactured Homes. So who's Bridge Property Management?
It looks like I don't know.
As I say, they have a management company who's taking the payments and everything. Yeah, it's.
All right. So you stopped making your payments in December of last year, is that correct? And
Yes,
you've been there for a whole
whenever
year?
I found out that the corporation I was making payments to was dissolved for cause.
And what is your response to that? About the Secretary of State and dissolved and that argument?
So two things, Your Honor. This is a derivative company under this subsection that she's talking about. It doesn't affect the rights of foreign filing entities. Subsidiary claims, this is them bringing it on behalf of the management company. They are registered to operate. What she's saying is they're not filed with the Office of Secretary of State. That doesn't mean that this particular one doesn't exist, but they're bringing the claim as well on behalf of the owner of the property. And
Well, there you go. And here's another thing that I found it crazy. Why are you so worried about what happens to your money after you pay it? You're going to get credited for the payment. I don't give a damn if you went up to them, took them some legal money orders with the real amounts written on it, and they just wiped their ass with it in front of your face. Turn around and say, okay, I'll see you next month. Why are you so concerned about where your money is going to go after you pay? Who cares? As long as you get credit for it.
as you see, they're both on there in the sales document, which I had highlighted to you. And that's who they're representing.
I'm going to object. They can't overcome the fact that they are not registered in the state of Texas, and under the Texas Business Organization Code, they cannot file any action or suit if they're not registered with the state of Texas.
Mr. Comp.
They cannot file any of their own suit. This is from the comptroller's office that's showing they are active and able to conduct business in Texas. That is that entity that she's saying in question.
Yes, they do have a tax ID number with the comptroller to do business. However, when speaking with the Secretary of State, they can't overcome the state statute that says that they cannot file action or suit if they are not registered.
Whether it's right or not, she still needed to pay her rent. And the second thing is she spent all this time researching instead of paying the rent.
How much was the monthly rent again?
Because this is why she was researching, so she doesn't have to pay. Listen, y'all. 99% of people's claims and stuff that they bring up in court is for the sole purpose of getting out of a debt.
$450.
The monthly rent, according to the original lease, is $450. They did raise it to $620, but again, it's not.
All right. And you're just asking for possession.
That's all, Your Honor.
Okay.
When you are in a landlord-tenant, you can bring up all those claims you want in general civil court. It's going to boil down to, did you pay or did you not in eviction cases? I'm sorry, you can bring up all the claims you want. That's what it's going to boil down to.
No attorney's fees.
Nothing, Your Honor. We just want possession. It's been 10 months in federal filings.
Oh, so all the federal filings was just used as a delay. Okay, I get it now.
Everything else, we're just...
All right. The court is just awarding possession only to the plaintiff. No court costs, no attorney's fees, no rent. Each of y'all have, both parties have 5 days to appeal, and the appeal bond is set at $900. So you have 5 days to appeal. All right. Okay. Thank you so much. Good luck to everybody.
There you go. Look, y'all, once again, now, we're about to go on a ride. I'm about to take y'all on a ride. I'm about to take y'all on a crazy ride. I was watching this last night, and I swear on my
So in the middle of the night, she fled with the kid to a hotel.
This is going to be very entertaining right here, y'all. Shout out to Team Skeptics. Got a lot of good work over there. Shout out to Sovereign Citizens Encounters. They got a lot of good work over there. Y'all like it, subscribe to them. They got very good content, good videos. This right here, I don't even have to give you an intro. Team Skeptics did a hell of a job covering this.
Near the Ohio border, and the FBI pinged her cell phone, and they waited for her to come outside, and they tackled her because she tried to run while she was holding my 3-year-old autistic son. Yeah, that May 5th, I'll never forget. That's the day that the FBI called me and said, "We have your kid. Can you meet us at the Cabela's on US 23?"
Hey guys, and welcome to today's video. Well, the day has arrived where I can talk about the sovereign citizen Karen who sued me and failed. Now, what started off as a video reacting to an obnoxious Karen's frivolous filings against me in the Eastern District of Michigan turned into so much more. So today will be part 1 of 4 parts covering a sovereign citizen Karen named Lindsay Dineski. Part 1 will be a set of court appearances, followed by an additional set of court appearances for Part 2. Part 3, we're going to take a deep dive into not just my lawsuit, but the other lawsuits that she filed against the many different government agencies and entities and any person that's unfortunate to get close enough to smell her. And Part 4 is going to be a surprise. Now, we have body cam footage, ring cam footage, and some wild court moments to get through, and I hope you'll bear with me through to the end. And if you see Chuck in the comments, be sure to show him some love and support. Now, this isn't going to be like my normal content. I mean, don't get me wrong, you're about to see the craziest Karen that I've covered on my channel yet. In second place isn't even in the same mental hospital as Lindsay Dineski. But before we begin, I'd like to thank today's sponsor, Ground News. One of the things I pride myself on lets me filter important precursor to the first hearing that we're going to cover today. So let's begin.
Dude, the day that we found your video, my mind was, I'm like, other people can know how stupid she is. Like, it was so fucking validating. And then I started seeing all the comments.
That's the father of her kids. She's talking to the content creator that was just talking.
Miss Manorino.
Yes, Your Honor.
Mr. Battaglia.
It gets just watch.
Our talk to Miss Dineski, and apparently she's representing herself. People versus Lindsay Dineski. This is set for the violation of the conditional bond, and also there's still the underlying case that is that there was a warrant on of the malicious use. What's the people's position on these cases?
Your Honor, as it relates to the bond, there have been numerous bond violations reported by Mr. Nerswick during the pendency of this matter. I believe there were at least 4 that were reported. Mr. Nerswick indicates there were more that he did not report, just so that he wasn't going to the police on a daily basis.
Right, I understand.
From her. It's clear, I mean, she made it clear during the pretrial with Judge Martin that she did not agree to the court's bond and wasn't going to abide by it, and she absolutely has not. There have been continued bond violations. I spoke with Mr. Nerswick for a moment this morning. He indicated that what he would like is no contact from Ms. Dineski, because the limited contact that he did afford her during the pendency of this matter, she has abused repeatedly.
Right, and so there's already a no contact in place, and she decides to ignore it. So what would you?
No, I actually don't. I actually don't. He was harassing me, and I only told him to stop harassing me.
Okay.
So if he comes to my home and he's harassing me, I have a right to say, you cannot harass me. And the only other time I talked to him was about the children, which I was told I was allowed.
Already. Look at it. Already. Already.
And I do not feel I can get a fair trial here, and I would like a change of venue, and I would like a trial, or I would like the charges to be dropped. I am not guilty of this charge.
Please be quiet so I don't have to mute you. Don't make
Well,
me
I'm
do
letting
that.
you know what I would like.
Miss Manorino, what's the people's position on all of this?
Your Honor,
and I'm aware that there's some ongoing thing with.
Yeah, he lied to get a court order. He stole my court document.
One critical thing, no matter what you're going to see and read or hear, one thing that's going to be a common denominator in a constant theme, no matter what goes on, no matter what happens, no matter what she does, no matter what she didn't do, it's never her fault. It's always somebody else's fault.
Documents. He's been harassing me at my house daily. He's had family members harass me. He's had other people texting me that are basically telling me what he wants to say, calling me a cunt, calling me a bitch, saying I'm never going to see my kids again. He's the one harassing me.
Your children's stuff is downtown. I mean, that's what.
No, this
that's
is
what
about
family.
The whole reason why. The reason why
But
he's
I'm
been
saying
harassing
that
charges on me.
court. I can't do anything.
Okay, but he's
about
putting
your
harassment,
children.
ma'am. Can I just? I'm in.
No, actually, it's my courtroom. No.
This is my hearing. You hear that? This is my hearing. Okay.
No, but it's my hearing, and I'm the defendant, and I have a right. I have a
You're
right.
right. You have the right to be muted, because I'm not going to continue to do this with you, Miss Dineski. I'm not. Miss Manorino, what do the people think that they want?
Your Honor, I don't know if because there have been so many.
I'm not going to.
I would like a trial.
Lock this woman up. Miss Dineski, you're pushing all my buttons. Listen, I'm trying to do.
Ain't 10 minutes into ain't 10 minutes into the hearing. God, wait.
I'm trying to figure out what Miss Manarino thinks she wants, because I'm not inclined to put you in jail. Although I am inclined to make you go and get a competency, because I think that perhaps you have mental health issues.
Judge, I was literally thinking the same thing.
You think? I mean, I called it in my last video. I even titled it, "This is what crazy looks like," when in reality, it should have been titled, "This is what a crazy, psychopathic, narcissistic..."
Responsibility.
I would
And
agree with
so
that, Your Honor. I think that would be helpful.
I'm going to make a referral for an out of custody for competency and criminal responsibility.
Well, like I said, I would like a change of venue because this court has shown bias against me and in favor of Chuck. So I would like to change venue.
I don't even know who Chuck is, so it would be hard for me to show bias for somebody
Not
that
you
I don't even know
but this
who it
area
is.
and the police have lied. They lied to have these charges brought.
I told you. It's never hurt. Cutting the judge off, being belligerent. Remember, this is one thing about them. When they don't get their way, it's always one big conspiracy against them. When they don't get their way, they always want to file federal lawsuits against the judge because they're not giving them what they want.
Doesn't change. Changing venue only takes if I change venue.
Yeah, and then you didn't.
I'm
You
not.
didn't on the eviction case that we had on the 10th. You did not even allow me a trial, which was my right, and you evicted me without a trial.
you had a 30-day notice to quit, and there was no lease. And I told you if you demonstrated a lease, I gave you 24 hours to bring me a proof of that lease, which you did not do. So I'm going to refer this for criminal responsibility.
Ma'am, you kicked me out of the room and you never told me that I could present the lease, ma'am. You never told me that.
I told you that you could present the lease within, listen, Ms. Dineski, bring me the lease today. Bring me the lease today then.
I will email it. I don't have a right.
I don't want it emailed. I want it brought live to the
then
court.
I'll have to mail it because I don't have a way to get there. I will have to mail it to you.
Then email it to the court.
And not only that, but he's the one harassing me and he's abusing the system to harass me. I was extending my good faith efforts about the ending of our relationship and our children. And he took that, and instead of going to mediation, which is what I was asking him for, he had the police lie on a police report, which I can prove that they lied. I have the evidence. And the thing is my liberty should not be infringed upon.
So he somehow convinced the police to lie on the police report. What is he, Don Corleone? I mean, come on now.
Because somebody else lied, and I can prove it. So that's why I would like to trial.
For today, before I do anything else, they're going to send you paperwork to get a criminal responsibility and a competency to make sure that you understand the charges.
Yes, but if I can, but you know what, if I can prove that
your behaviors, all of your behaviors, Ms. Dineski.
What behaviors? Standing up for myself?
Evidence.
Standing up for all I have done is stand up.
No. It's given MH. Like, look at your eyes when you talk. Like, you can't shut your pie hole for 2 seconds. Like, it all everything taken in whole. Yes, there's something clearly wrong with you.
For abuse, ma'am. You guys are helping an abusive victim because he has.
And that's your opinion today, and you're entitled to that.
And I have
but I want to make sure that you're competent. So today, I'm going to order the competency and the criminal responsibility, and we'll go from there. Ms. Manarino, we'll let you know once she's done that. Okay.
Yes, Your Honor. Thank you.
So when you get the paperwork, you've got to do the referral for.
Yes, but if I have evidence,
how do we send her the referral for that?
So if I have evidence that this,
I have to check with Heather.
Okay. Your evidence, you'll have an opportunity once we establish that you're competent.
Yes, but why should I have to take a competency test if I can prove with my evidence that these are felonious charges?
Because that's what you do at trial. All this extra bullshit that you're pulling right now is what's cause for concern that you might be a certifiable nut job who needs constant monitoring by a doctor in a room with padded walls.
That they're are totally
because of
erroneous.
your behavior.
I'm gonna let it play because I want people to be like, "Oh, you let the black guy do the commissary, but you're skipping the white guy." So, yeah.
Behaviors and your antics.
What
we
is
have
what
reason to
behaviors? I don't have
believe-
any antics, ma'am. What antics?
Mhm.
Can you give me a lawful reason why you're going to order me to do
Well,
something against my will?
All of your interruptions and your rantings make me question whether or not,
rantings.
and you've made
What did
statements
I rant
about
about?
having
I
mental health
asserted
issues.
my rights. So you're
I know that
retaliating.
you have a psychiatrist. I know you have a psychiatrist, which
And
leads
that
me
should
to
be good
believe that
enough.
there may be some mental health issues.
No, I have
And if your
ADHD.
psychiatrist says
No. That ain't ADHD. That's we way beyond the ADHD stage.
you're good, and it's my responsibility to make sure that you're competent to proceed. And so that's what I'm
Yes,
going to
and
do.
I have ADHD,
All right.
very
And
well
Judge,
controlled, ma'am.
yeah,
And the thing is, that
Heather, we will send the paperwork to the forensic center. They will contact Miss Duneski and send her the paperwork as long as we have a good address on file. But that's where they'll send it to.
Okay. Okay.
But
So
what
you'll
I'm
reach,
saying,
because it's
ma'am-
not your psychiatrist. We have the state
Yes,
psychiatrist.
ma'am, but
talk
I
to you.
should not be forced to take a mental
I
eval.
note your
When excuse me, let me finish, please.
Yeah.
When I'm been asserting my rights, there's no antics. I have quoted laws to you. I have quoted my rights that I'm entitled to under the law. So I don't understand how you could see that as antics.
So anyway, Ms. Dineski, it's
Judges roll right over top of that.
you've mentioned the psychiatrist multiple times, and I just think it's everybody. And I do this. This has nothing to do with you. This is.
Well, I'd be
to do
happy to
with
provide you. I have a letter that I just got from
not
my therapist. I
providing
have
from
one
your
from my
psychiatrist. I
psychiatrist,
want
and
you
I have
to
a
be.
full. Can I please just can I have a chance?
Well, except that your psychiatrist is not someone that is experienced
didn't
in
let me finish.
doing
I have another
competency
thing.
evaluations.
Okay, but I actually had a
Ma'am, you just babbling. All you're gonna do is just keep repeating yourself. And
competency evaluation by the state of Michigan as well.
Okay.
Already.
When was
So
that?
It was 2019.
I suggest that when you get the competency that's now that you take that paperwork and give that to them.
So I'm perfectly competent. I don't understand because I'm asserting my rights why you're retaliating against me and telling me I need a mental eval because you don't personally like the way I speak or because I have age. So you're discriminating against me because I have.
Told you, look, follow along. Every time she hears something she doesn't want, it's either retaliation against her, discrimination against her, conspiracy against her, don't want her to own her. Watch the common theme.
ADD. So that's part of the reason why I interrupt. And so that is actually under the ADA, you're retaliating against me because of my ADD.
It's not retaliatory.
Yes,
There's
ma'am,
nothing
it is.
retaliatory
Well, then
about
can you
sending
please give
someone
me
for a
one reason why
competency.
you're infringing on my liberty by forcing me to do
Well,
a
you
mental
can
eval?
file an appeal.
I
You have that
will.
right. I make a decision and you
the
can
police
file
are
appeals.
corrupt. The police
In the
who are helping
meantime,
him are corrupt.
we're done for today and you're going to get something from the forensic center and you have to go and participate in that process. And obviously you've already done it once, so you know what it.
Yeah, I mean, I
you know what
don't
it's
mind
like.
taking the eval. I just don't have a ride there. I don't have any way to get there. And, you know,
And I'm
I'm
not
trying.
so sure that they don't do them by Zoom now.
And that's fine if that's what they want to do.
Okay.
But, you know, this man has made it so he's destroyed my life. And instead of them helping me, these police, they won't let me file charges against him.
And
I don't to my house when I'm sleeping.
I don't have supervisory over the police department. I don't do anything.
No, but I'm telling you that he has been violating the law and they won't help me, Judge. They won't help me.
Here's a suggestion. Maybe stop being an insufferable piece of shit. And people who don't have an obligation to help you out might just find it in their hearts to go out of their way to do so. But after hearing all the shit that you put your family through, if I came across you in the middle of the desert and you were on fire, I'd drink whatever water I had and piss on myself before helping you out.
I'm the one being abused and I have witnesses. As literally all my neighbors, I've had to have people stay with me for my own safety. And he's saying I'm harassing him. And then just please hear me out. He went to Washtenaw County. He lied about his address on the paperwork so he could go to Washtenaw County because I had a PPO against him and his ex-girlfriend, who he tried to kill, had a PPO from before. And so he didn't want to go to court in Wayne County because of all these things. And then he started making false allegations about, I was trying to talk to him about our children. And one of our children he took. And I was worried about her. And then the other children he wouldn't support. So me having a good faith effort and I had a reason to talk to him would be different if I was just harassing him and threatening him. I was just saying, if you do not, take care of your children and you don't let me see our other daughter, then I will have to take legal action. That is not harassment. That's asserting my rights. And he has abused the system, and he went to Washtenaw County and he filed stuff there with no jurisdiction because he lied on his, then he should not be considered credible. And you can call the court yourself in Washtenaw County and find that out. He's the one who needs a mental eval.
You can tell the judge can call the girl.
Because he has lied. He has stolen my court documents out of the mailbox. I have shadow of a doubt proof that he has done that, and the police will not investigate it. They have refused to investigate federal felonies. He stole at least 4 court documents, so I did not know.
If you can't get Van Buren Township to do it, then you should, I suggest that you go to Michigan State Police and make the complaints with them.
Ma'am.
Look, told you, like, no one will help her. If she tries every single avenue ever known to man, they all just say no. Like,
it is their jurisdiction. When there's an allegation against the local police department, Michigan State Police will get involved.
Yes, ma'am. But I tried. I have proof that I
or
tried
the
to call
sheriff's
them and they won't
department.
what has it ever crossed your mind that your claims are frivolous? Have no merit? I mean, has that even just crept up in your mind? A remote possibility?
So I'm telling you as a judge that the law is being broken and that your court is being used to abuse me, a victim, and nobody's listening to me.
You
So I don't
have an
know
opportunity. There's nothing that's happening on this case right now. It's pending still. So there's nothing that's happening.
Yeah, but you
on
have to understand that because of this case.
I am telling you, though, that as long as this case pends, and obviously, even for your best interest, you're better off not having any contact with them.
Well, no, here's the problem, Your Honor. With this case pending, they're not going to give me custody of my children, which that's the whole point of this.
This case, I've never seen anyone with a case such as yours. It's a telephone harassment that someone
which is
their
why
children
it should
back
be dropped
because of that case.
Well, he's using that, and he used it to get a PPO, a fraudulent PPO. So he's using fraudulent charges that I can easily prove that should be dismissed based on the fact that there was no malicious intent and based on the fact that I had a reason to communicate with him. And so that's protected free speech.
Well, but from today forward, I'm telling you, you shouldn't have contact with him now, though. It's only causing you more problems.
He has my children illegally, so he won't even tell me how the children are.
The judge that's in charge.
That's funny, because as I remember this story, the FBI didn't ping Chuck's phone to get his location. They didn't tackle Chuck to the pavement when they found who they were looking for. And they certainly didn't hand the kids back to you when they retrieved them from Chuck. No, they pinged your cell phone, tackled your ass, and returned Chuck's children back to Chuck.
The judge that's in charge of deciding where the children go, that judge is not going to look favorably if you continue to have contact when you've been told not to. I'm just giving
and
you
that's
some
fine. I
friendly
understand
advice.
that, and that's fine. I understand that. I don't want contact with him except for about our children. And right now he is illegally, he's in violation of MCL 7.0 or 7.50 parental kidnapping. He lied.
But that's not I can't do anything about that. Even if all of that's true, I don't have
but Sumter won't
authority.
press charges against him, ma'am.
It's in front of a judge downtown that's made a decision, I imagine.
No, it's not. That's what I'm trying to tell you. Please listen. Please listen. I told you he filed in Washtenaw County knowingly that he did not have jurisdiction there, and he lied about his address and put a fake address.
Well, then if it's in Washtenaw County,
you get the common theme. Like it's just like, and she thinks her antics in court, her mannerism, is going to help her cause of getting her children back.
It was vacated.
Go deal with family court there.
No, we don't, because there wasn't jurisdiction, and he stole my court documents, which I proved to that judge, and she had to vacate it. And he lied to the FBI.
Well, then if there's nothing pending right now, you need to file something in Wayne County in family court.
So she said he lies to the FBI. So so basically what she's saying is anyone could go up to the FBI, make up a lie, and they're just going to run around and just go off your word. They're not going to validate it. They're not going to see if you have a court order. They're not going to do none of their research. They're only the largest investigative firm in America. Oh, they're just going to take a civilian's word and just go Right.
saying that. That's my, yes, and I'm doing that, but what I'm saying is that this is going to be used against me, and that's a violation of my liberty because these
Well, you
charges
haven't
are
even
erroneous.
filed it yet, so it can't be
Yes, I
used
have.
against you.
Yes, I have. I have filed.
Well, you
it.
just said there was nothing in Wayne County, so you're being
No, I didn't say that. I said this. What I was,
contradictory.
no, that's not. You misunderstood me. I said what he filed was not in Wayne County.
Okay.
He
Okay.
took it and
But
went
if you
to
have a Wayne
Washington
County
County.
action, they'll make a decision. But I have a lot of other
But in the
cases today,
meantime,
and I think I've
he has
given you more than
illegally.
enough time.
But you should be able to tell him to tell me what's going on with the kids. He took two.
You should be able to tell me to tell him to tell me what's going on with the kids.
I can't do anything about the kids, Ms. Dineski.
Well,
I don't
then how
have
come-
jurisdiction over the children.
But the last judge said I couldn't contact him when it came to Haley.
I
And that's
said
one
that
of my
you can't have
children, too.
contact with him. I can't tell him what to do with the children. That's an issue for family court.
No, but if he's
All right,
breaking the
for
law,
today,
this is a criminal law,
we're all
ma'am.
set for today. All right, and you'll look for something.
Just end the damn hearing. She's gonna keep going and going and going and going and going. Just end the hearing.
From forensics.
Okay, thank you.
All right, so that was the end of the first of 6 hearings. At this point in the story, Chuck was not allowed to be at the residence because Lindsay Dineski filed a temporary PPO ex parte. That PPO was granted, but was later rescinded because it was frivolous. But it still resulted in Lindsay Dineski squatting in Chuck's cousin's home, and this is her first eviction hearing to get her out.
On Deborah.
Shit. Grab your popcorn, y'all. Hit the like, share, drop like, dislike, it don't matter. Still hit the algorithm. Hit the like and share, y'all. It's about to be a doozy.
Cripps versus Charles Nerswick and Lindsay Dineski. The last hearing, I had indicated that the plaintiff was entitled to possession. I asked if there was a lease. You said that there was not a lease. Ms. Dineski said there was a lease. Subsequent to that, Ms. Dineski sent documentation to the court of text messages from your client indicating that there was a valid lease through September of this year, which brings me back to the conclusion that there's something in writing that your client indicated, even though it's a text message, but that constitutes in my mind some type of a lease. Unless Ms. Dineski isn't paying rent or there's a violation of that agreement, there is something in writing that says, although it's not a typical lease, there is a written document that says that she leases the premises through, I don't remember if it's September 1st or September 30th, whatever it is. That's a problem.
Okay, I think I have a copy, Judge, or someone copied me. I think a text message.
You liking what you hear? If you liking the information provided on this channel, please do not feel I will not hold it against you if you show your support through the Cash App. I swear to God, we will not hold it against you. We won't be mad at you. We won't ban you from the channel. We won't disparage you for doing it. We won't laugh at you. I swear to God that we won't do any of the above. Let's get back to it.
I don't have text messages, plural. But
Yeah,
this,
a text message that says the lease is until whatever, blah, blah, blah.
yeah, but Judge, there is no signed lease. We don't have any signed lease by the parties.
Well, it's a determination of whether that communication from your client constitutes an agreement for a lease that through September.
Okay.
I mean, you're right. If the text had been from Ms. Dineski to your client, I would agree with you that your client didn't agree. But the text is from your client to her.
Oh. I'm not sure what that is.
It's Mr. Beal. Mr. Beal, mute yourself. Thank you.
Oh. Yeah, but Judge, there's no indication of any acceptance of that.
That's to have a hearing to determine whether there is or not.
Oh, okay. Well, that's fine, Judge. I wasn't sure, Judge, when I had filed my writ, because you had indicated at the last hearing that Ms. Dineski would have to provide that within 1 day. I didn't hear anything for.
Right, no, I know. And then she provided a bunch of documentation and then they brought it up and then, by the time I looked at it, I said, she's got, go ahead and set it for a hearing.
Oh, okay.
But my
yes.
question to you, I guess my one question to you is, there is no allegation. She's continuing to pay rent, correct?
Well, I think my client could probably answer that, Judge, because I was approaching this as a termination, not as a non-payment. I think
right.
Mr. Nerswick, up until one point, was paying rent, but then there was no rent being paid. So, I mean, you can ask. I have no problem with the court.
Has there been rent paid, Ms. Cripps?
The last time rent was paid was February 1st. So March.
That's what I did ask.
I'm sorry. Let me back up. March 1st was the last time that.
Lawyer, are you at the office or are you at your house? Looks like an office.
Rent was paid. So April, May, and then tomorrow rent would be due again.
Right.
And they harassed me out of the property, so I haven't even been living there. And I tried to do a goodwill and good faith.
Well, if you're not living there, Ms. Dineski, then
I didn't want to move.
Look. Once again, somebody's always doing something wrong. Like, I've never met, like, every step of a person's life, somebody's just attacking them. No rhyme or reason. Big conspiracy. The whole world. She is 7 billion people on the planet. And she is the focus of everybody's attention in everyday life. So they have to, like, what the fuck is wrong with this lady?
Because I was forced out. They changed the locks. They harassed me illegally, mercilessly.
Okay. No, but let me.
Once again. How? What legal basis? You just, like, for what? For what? What is the reason for harassing you? What is the reason? Maybe it's you. As a matter of fact, it is you. You're the problem.
Let me just stop you. Then you can file a separate lawsuit against her.
Which I plan on doing, but I was forced out of the house.
Okay.
I told you, look, I told you. There's always a reason why she can't do something. She's always being prevented. If someone's always, oh shit.
But you're not living there anymore, correct?
Well, I want to live there. I never wanted to leave. I tried to make an agreement to pay rent with her. She refused to communicate with me. Then they filed the eviction.
So
I don't blame her.
You want to access the premises so you can come post the bond for the 3 months rent?
I mean, I at least want to get the rest of my things.
No.
At the very least. And I was.
What the hell was that?
Like,
okay, then how much time do you need to get the rest of your things?
Well, I'm not sure because every time I've gone back there, there's been someone there. I don't even know if my things are there or not.
It's always an excuse.
I need to at least go and assess what is there and see what's going on at the property because I haven't been able to go back there since that I haven't gone back since the one day that you said that the eviction would have taken place.
No. I said I was going to give, I still haven't signed the writ.
She's always lying on the judges too, y'all. She will put lies on it. This is a dangerous woman right here. She will lie on anyone and anybody to get her way. This is a very dangerous person for real.
I'm trying to get you to tell me.
I know, but you gave Charles a PPO against me.
I didn't give any PPO.
I got a paperwork that said that you gave him a PPO.
I don't issue PPOs, Ms. Dineski. That's not even humanly possible. I don't issue PPOs. I'm not a circuit court judge. There's the circuit court judge does the PPOs.
It must have been a fraudulent paperwork that he had.
It could be.
There you go, right there. A fraudulent PPO. It's always a grand conspiracy against this person.
And I'll send that to you so you can see how fraudulent these people are and how corrupt They are, and I would like an investigation because the
I
police
don't
refuse to-
investigate.
but you
That's
can
not
order
my
the-
job.
Well, the police refuse to investigate, so.
And I can't
order that.
force they're a different branch of government. There's nothing I can do about
But
that.
it's funny because judges will order the police to do stuff like take my children unlawfully from me.
I did not have anything to do with taking your children either.
No, but the whole entire eviction and the whole entire false charges of the malicious use of the phone, which
And
I've
I
asked to
brought
have
you
dropped.
back when you sent the text message that said that Ms. Cripps
Yeah,
had
but you
given you
also
access to the property.
But you
And
also
now-
issued a fraudulent bench warrant against me when my daughter had a blood clot, and that caused the police to arrest me and take my children and give them.
I issued a bench warrant against you because you didn't appear.
I did.
Hey, there you go. There you go. You got a bench warrant issue because you did not appear. Those are your actions. No one was holding you down in the basement somewhere.
And then when you did
I
appear, I
did
withdrew the
appear,
bench
ma'am.
warrant.
No, you did not. I was arrested falsely because of Charles.
That didn't come from me. The arrest
fraudulent.
for-
Why did I get a bench warrant when my daughter had a DVT? And I called
have
and I
no
gave her-
idea.
Well, that's what happened.
Well, I'll tell you what I'm going to
So
do.
because of that fraudulent
I'm gonna
warrant,
give
my
her-
children were taken
I'm going to
away
give
from
her,
me.
Mr. Robinson, I'm going to give her 2 weeks until June the 15th to get her stuff, and I'll sign the writ on June the 15th. So you have 2 weeks to go into the premises.
No, Your Honor. She wants to go back in the house and live rent free because there was some grand fraud and conspiracy committed against her. So her redress is for her to live in the house and not have to pay for it.
Probably not, but go ahead, Mr. Nerswet.
And he is muted. Have to mute your mic.
Yeah, he follows me around and comes.
Well, but
to
if
where I'm at.
but if you have a PPO, then any of
has
her
your-
stuff
ma'am, it
is
has your
there,
name
then
on it.
she has to be able to do a civil standby to get her stuff.
Yeah, but it's my stuff.
I think he is being muted out on purpose. I'm not sure, but it does look like he is talking.
Even there.
Yeah,
And I
she
want
has
my
to do,
children
you have to
back,
have the
ma'am.
police
I would like to
department
have
go
my
back
children
with
back.
you.
He
But
kidnapped
when
my
I
children because of the warrant, the fraudulent warrant that you issued. And so I have a right to have you order a pickup order to.
See how disrespectful she is? Like, she is very vile and disrespectful to the courts. The fraudulent warrant that you issue. And you talk to these judges like this, but then you expect them to do things for you. Like, you got to have respect for the court. This is a weird cookie here, boy.
Get my children back because of that warrant that you.
I don't even have the jurisdiction to do that.
Yes,
I
you
thought
do.
you said you went
Any
to law
court.
school.
Yeah, but let's be real. When she said she went to law school, I don't think she meant she attended any law school that didn't require her to eat pain as part of the curriculum.
I don't have
can give
any
you the Supreme
jurisdiction
Court
over
proof.
children.
Anytime my rights are interposed, any agent of the government and I can assert my rights to any agent of the government. I can read you the case law if you would like, but because of a mistake that was made by this court, the police took my children from me and gave them to him, and he does not have custody of them. He doesn't even have a legal right established to the children because paternity.
Okay, you can submit that to me.
Hold on. Did you just say the father of your kids doesn't have a legal right because he has an established paternity? So this is a dangerous person. So you would and this is one of the things about people like her. When they are upset and not getting their way, they will say anything out of their mouths. They will say the most vile, nasty, disgusting, demeaning, below the belt things when they are mad or don't get their way. She has the nerve to now say, well, he shouldn't have the kids anyway because he has an established paternity. So you're implying that those two kids may not be his. They will say anything out of their mouths. There is no filter. There's no split second to think about before they say things. And then once they cause destructions with their tongues, they expect the world to have all this understanding and for somebody to come bail them out of being in the situations that they consistently put themselves in. Yo, people like her are not only a danger to themselves, but they are a danger to those that are around them.
And I'll look at it if you want me to
Thank
sign
you.
something.
Yes, please. I would really
Defendant,
appreciate that.
defendant
Because he
to,
has kept the, I just want you to know he's kept the children away from me illegally since May 6th. He has not spoken to me about them. He has not let me see them. And they are 3 and 4. And one of them I was still nursing. So I will send you that. And I would really like.
if you're still nursing a 3-year-old, that's a different conversation.
No,
Right.
that's not. If the La Leche League says 3 years old is optimal.
I said it's a different.
What the hell? You're nursing a 3. Yo. What the fuck is going on?
Different conversation. I didn't make a judgment on it, Ms.
I'm just saying
Dineski.
it's traumatic. The point is it's traumatic for the
Defendant to
children.
remove her property by June 15th with a civil standby.
Well, it was
Writ
gonna
to
take
issue on June 15th, Mr. Robinson.
It might take me a lot longer than a civil standby to get my things. And
I can't help it. He's got a PPO that I don't have anything to do with.
The
I can't
PPO
tell
has
you
your
to
name
go
on
get
it,
your
ma'am.
stuff.
I think
The
it's fraudulent.
PPO does not, Mr. Nerswick, who signed the PPO? Thank you. Thank you very much. My name's not on it, Mr. Dineski. It's Judge Triplett. Writ to issue.
Look, she just talking. Look at her. Look at her.
June 15th. Yes, Mr. Nerswick?
I don't know why he's muted. I don't know why he's muted.
That is not true at all. He's a liar.
That's fine.
Yeah, I
I'm
haven't been
just
there in
gonna give her
weeks
2
either.
weeks and Mr. Nerswick, she can either come with the civil standby or she can appeal me.
That's her. Okay, that's the children's father right there, I believe.
Those are the situations. All right, Mr. Robinson.
Judge, just so I could clarify, you're going to hold off signing.
Yep.
I know he filed the
2
writ.
weeks.
So. Okay, thank you, Judge.
Yes, thank you. Thanks. Everybody's all set. Bye.
All right, so that's the end of the first eviction hearing. Now we head to Judge Oakley's courtroom for the next hearing.
All right, Judge, next is.
It's woof. When I talk about it, just intensifies as we proceed.
Cripps versus Nerswick and Dineski.
Thank you.
Morning, Judge Steve Robinson, appearing on behalf of Paula Cripps.
Oh shit, this judge don't play. Oh God.
Good morning, Mr. Robinson. Ms. Dineski, can you hear me okay?
Yes, sir. Yes, Your Honor.
All right, and do we have a Mr. Nerswick?
Yes,
as
Your
well?
Honor.
All right, thank you. Activate your camera if you've got it, Mr. Nerswick. If you don't worry about it. Mr. Robinson, what are we doing?
Your Honor, I've had an opportunity to speak with both Mr. Nerswick and Ms. I apologize if I'm pronouncing that wrong, Ms. Dineski. Mr. Nerswick is in agreement. This is a termination of tenancy, Judge. It's not a non-payment. Ms. Dineski has indicated to me that she's filing a motion for change of venue due to wrongful prosecution.
Told you. As soon as she don't get her way in one court, she want to go to the next court to get her way. She don't get her way in that court, she want to go to the next court. She don't get her way in that court, she want to go to the federal court. She lose in federal court, she's go files a lawsuit in another federal. Like this, it just doesn't stop with this person.
Quite sure the substance of that, Judge, or how it relates to our particular case. Like I said, this is done pursuant to a 30-day notice to quit back in February. And that's where we're at, Judge.
Mr. Dineski, explain to me what your motion is going to be about.
Well, I wanted to ask for a change of venue due to there's other proceedings in this court where I have been mistreated and maliciously prosecuted. They have shown bias against me and in favor of Charles Nerswick and the Van Buren police who have in violation of. And it's this eviction. Well, up until the point where it became before this court, it was just the Van Buren police and Charles Nerswick, and I would say also Miss Cripps because he's related to her. They're cousins, and he attacked me, and I kicked him out.
You're getting off track.
Oh, no. When you ask her a question, she just want to rambles about everything she wants to talk about. She's gonna, so you gotta wheel her in, Judge. And she's just gonna ramble, just keep rambling on.
No, I'm actually this is retaliation. The eviction itself is retaliation.
Okay. Well, that's all right. Well, you're not going to get a change of venue because you think it's a retaliatory eviction.
You know, but then things have happened since then where the court has entertained malicious and frivolous charges against me that don't even have jurisdictional basis or standing at all to be brought. And they've issued a fraudulent warrant for my arrest, and they have sent the police to my house to harass me multiple times. And I just don't feel that you seem like a very...
That's enough. That's enough. All right, Mr. Robinson, we'll spin this off to one of the other judges and the lady can file a motion.
Well, it's not you that I have a problem with, it's the other judges, sir.
No, but Mr. Robinson's law partner is my wife, so that wouldn't be appropriate for me to hear this.
Oh, I see. Well, I think it should be in a different venue because the other judges...
Well, you'll have to file a motion for that.
Okay.
Oh, so that's why I didn't stay in front of him. I wish you would have stayed in front of him to chew her up and spit her out. That's why. So Attorney Steve Robinson and the judge's wife are colleagues.
Well, I mean, I was going to say, if you believe that you could be impartial, because so far I've watched several of your cases, you do seem like a good impartial judge. And as long as you can assure me of that, then I would be happy to proceed. I just wanted you to know my concerns because I definitely feel like the other judges in this court have maliciously prosecuted me unfairly. And one of them issued an unlawful warrant, which I will be suing the court for.
I guess they forgot to tell you about the immunities that judges and prosecutors enjoy in that super real law school that you attend. In other words, you won't be suing any judges or prosecutors. Well, I take that back. You will, you just won't win any. And you can stop with the excessive complimenting of Judge Oakley. He just told you he was married, and he doesn't seem like the type of guy that's interested in anyone that smells like regurgitated crayons.
I appreciate.
That is true. You cannot file a lawsuit against any actions taken by the judge or rulings of the prosecutor while in the performance of their lawful duties. It's the immunity. The judges, they have immunity for these type of lawsuits, especially these frivolous lawsuits in which they only file these lawsuits when the judge doesn't rule on their frivolous motions or arguments.
Your assessment of my character, but it would really be a bad idea for me to hear a case that my bed partner, her law partner, is on the other side of the case.
That's understood, sir.
That's not smart for me.
And I appreciate that. Thank you, Your Honor. You are definitely an honorable judge in my eyes.
Thank you. So you'll be able to file your motions in front of whatever Judge Martin or Judge Green this ends up in front of, and they'll hear your motion. If Mr. Robinson wants to argue against it, they'll hear both sides and they'll make a decision. Understood? Are
you able to dismiss an unlawful warrant in this court that didn't have jurisdiction? Because my liberty right now is being infringed upon by this court. And I can't even leave my home because they have the police watching my house for something I didn't do. That.
Let me answer it this way. If one of the other judges in my building made a decision, I can't rule on an appeal to that. You can't appeal.
Not an appeal, but I'm attacking the judgment based on the fact that
me 4 times. 4 times you've interrupted me. I'm not putting up with a fifth. I'll just remove you from the meeting. You've asked me a question. I'm attempting to answer it. If you want me to answer it, you have to be quiet.
Yes, sir.
If Judge Green or Judge Martin issue a warrant and you think that decision is wrong, you cannot appeal their decision to me because we're all on the same level as district court judges. If you want to appeal a decision made by a district court judge, you have to take it to the circuit court.
Yes, sir. I'm not asking for an appeal. Let me clarify. I'm attacking a judgment, and there's Supreme Court rulings that say that I can attack.
AKA, it's an appeal of the decision, you dingbat.
A fraudulent judgment or a judgment base that doesn't have jurisdiction in any court at any time.
Okay.
So I'm proper, as long as I'm properly before the court. So that's why I was just, that's why I was asking. If it's a void judgment.
Before the court. You're asking me to make a decision on a case that's not mine. So I can't do that.
Okay, I understand. Thank you.
Judge, may I
So I'm making a note in the file that this case will be blind draw to one of the other judges. I would suggest that you file your motion as soon as you can, so we don't have to let too much time languish on the file.
Judge,
Yes, sir. Yes, Your Honor.
Judge, if I may make a request for an expedited hearing date, and without trying to poison the well, there's been several police runs to this residence. There have been people that have moved in. There's been removal of personal property. There's been, we're not allowed on the property to make maintenance or lawn mowing or other matters. So it's really become quite problematic, Judge. So
yes, but I'm responsible for the lawn maintenance, so there's no need for that.
okay.
And I've only sold my own personal property and no one else's. So this is not
just
true.
Stop talking, Mr. Nesky. Mr. Nesky.
Well, he's making false statements against me.
All right, goodbye.
And just like that, Judge Oakley joins me on her federal civil rights lawsuit list. So that's the end of the eviction saga. She was eventually evicted and the property was returned, completely destroyed and in disrepair. From here, we head to our final hearing of today, which is an arraignment for a malicious destruction of property. Now, before we start the hearing, I have a few Ring doorbell videos to show you of Lindsay Dineski approaching not Chuck's house, but Chuck's ex-wife's house and started banging on the door with a 2x4 and a brick.
Lucas! Allie, Lucas! Mommy's here! I miss you!
You need to get away from my house.
No, I want my kids! They canceled the court order! They vacated it because
I'm gonna tell you right now, bitch, I ain't even working. If you're still there, you're gonna get fucked up.
They're here! No! I want my
fuck away from my goddamn house.
Call the police!
And here is a picture of the damage done to the door.
People versus Lindsay Dineski.
Okay.
Good morning, Ms. Dineski. Do we have Mr. Jadala on here? My understanding is you spoke to Mr. Jadala and that you're asking for an adjournment. You're asking for discovery and an adjournment. Is that correct?
Well, I'm asking for it to be dismissed first and foremost because there's no crime. I went to a house where my children were being held illegally and I knocked on the door. So I don't understand how that could be considered malicious destruction of property. And I do not believe that there's enough evidence for there to be any charges whatsoever against me for malicious destruction of property.
Okay.
Especially since there was no malice and I
Well,
went there
I mean,
to
it's only
retrieve
set
my
for a
children.
pre-trial today, and I know you're versed in the law, Ms. Dineski, so you understand that at this point, I can't entertain a motion to dismiss. It's just set for a pre-trial today. And so, yeah, go ahead.
Yeah, but if there's no evidence, there still has to be evidence.
Ms. Dineski, Mr. Jadala wants to speak on your behalf. Please let him.
Your Honor, I've spoken to Ms. Dineski, and I understand that she wishes to proceed representing herself. What I've advised her on, I would ask the court to do, is she's respectfully requesting discovery. She doesn't have an address. She'd like the discovery to be available to her at the court so she could pick her up. And I told her after a review of discovery, she may file a motion to dismiss, present it to the court, and you could rule at that time. She understands
yes, and that's
that
what I'm
process.
doing, but I wanted to just say that I had the intentions of wanting it to be dismissed.
No, I understand that. Mr. Young, can you produce the discovery at the court within the next couple of weeks or whatever?
You want me to do it at the court?
Yeah, she doesn't have an address, so.
And that's not going to change anytime soon, unless the post office starts issuing addresses to 7-Eleven dumpsters.
Or if you have an email, you can email it. You can upload and email it to her.
Yeah, well, I'm going to need the body cam footage. I'm going to need all the phone calls from Sumter Police. I need all the police reports from Sumter Police because I've made several police reports that they ignored of these people harassing me and attacking me and doing lots of unlawful things.
In this case, Ms. Dineski, the discovery in this case is limited to this case.
Well,
it's not discovery of everything. It's
yes,
limited. The discovery.
I'm asking. Yes, excuse me, ma'am. I'm asking for discovery.
Speaking, and it's my courtroom, and you know how I am, Ms. Dineski.
No, this is the people's courtroom, ma'am.
I will mute you and not allow you to speak. I'm in control of the administration of being able to control my docket, and I will remove you if you try to talk over me.
Well, you were talking over me. I was not finished talking, and the other evidence is
talking. Ms. Dineski,
the other
talking. Ms. Dineski, if you unmute yourself again and try to speak over me, I will remove you. I'm just telling you. Now listen to me. I'm only requiring Mr. Young to produce whatever the people have in this case. That's what discovery is. It's documentation or evidence that's going to be used in this case. And if he doesn't produce something and he tries to use it at trial, then that's a violation of the rules of discovery. So whatever documents, I don't know what Mr. Young is going to try to use at trial in this case. Mr. Young, do you know enough about it to tell me whether or not it's just testimony of witnesses or whatever it is?
I don't. Police reports for sure. I don't know if there's any body cam or not. And I have some information from those who suffered as a result of this incident. So I will have probably those documents and that information, and that's it.
Well, my point was in saying the other evidence that I'm talking about shows that this is a case of malicious prosecution by the police in Sumter and by the people who are filing the charges. So that evidence would be relevant to this case because it shows that they were actually maliciously destroying my property. They kidnapped my children.
Well,
they
if you have
were attacking me.
Police reports that you want, Ms. Dineski, you have to list out what days you made a report or whatever it is.
Well, wouldn't it just be easier to say?
Only knows, Mr. Young only knows about whatever police report from the date of May the 8th.
And
He's not going to know
get
if
that,
you
but
call
wouldn't it?
the police on May the 1st, Mr. Young's not necessarily going to know that, and he's not going to use that. So it's up to you to get from the police department any police reports that you file.
Your Honor, she has every right to FOIA that information as long as it's unrelated to the charges before the court. Now, I will give her the discovery as it relates to all those matters.
Yeah.
But if she wants to go back in time, back into the Wayback Machine, that's fine, but she has to file the FOIA request and obtain it that way. It's not really a matter of discovery. I'm not using it.
I thought I could request discovery for my side as well.
As her defense. I mean, she's entitled to documentation
And if
for her defense, but she has to connect it to the date in question. It has to be directly correlated to the May 8th incident.
I don't personally see why the court should have to hold her hand and walk her through discovery when she wants to represent herself. And I don't think the prosecutor wants to spend his entire day trying to help this dipshit beat a case that she's clearly guilty of.
Here's what I'm
Well, if I'm claiming malicious prosecution.
Go ahead, Mr. Young.
I don't have a problem looking and trying to get copies of reports and seeing what I can print. But what I'm concerned about is that I may not hit everything because I'm not going to sit over in the police department for all afternoon trying to figure all this out. I'll go there and I'll try to get some reports, and I don't want to come back that somehow I'm withholding evidence. So it's much easier to say, I'll give you the stuff as it relates to this, but I will represent to the court that I will see what other reports I can get.
And if she has any other specific dates, you can look at those dates. Do you know what I'm saying?
Can't you do it by address and name? You should be able to pull up an address and get, because that's how I did it through Van Buren, but Sumter.
You know what, Judge? Here's what I'm going to do. I'm going to get the discovery for this case unless I get an order otherwise, and the order's got to specifically say what you want me to do. I'm not, see, this is my point. We're going to go around and around and around like at a carnival, and where we land, nobody knows. I will produce the evidence, the documents, the discovery as it relates to this case 1 week from today. I'll leave it at the front desk. Anything else has got to come to me in an order.
Okay.
Well, that's what I'm asking for, is for the judge to issue a subpoena to Sumter because they are maliciously prosecuting me and they will not cooperate with anything that I ask.
In the first place, I'm not going to issue a subpoena. If there are specific dates, Ms. Dineski, you can give us the specific dates, or you can go to Sumter Township and FOIA for those specific dates for documentation.
Well, every time I go there, they refuse to help me.
Then Ms. Dineski, tell me.
That's why I'm asking the court.
Sure, give me what dates. Give me what dates besides the May 8th date, which he's going to give you. Give me the other dates that you need a police report.
There's probably between 15 and 20 different dates because that's how bad the
Give me the dates.
Well, I'll have to, I mean, I'd have to email them because I don't have them off the top of my head. I have to go and look at all the times I called there.
That's not how it works. You can't email the
Well, that's why I said if you just ask. Well, I mean, I just don't have the date. I mean, if you want to wait, I can look them up, but it might take quite a while. I didn't want to keep you from the other things you have to do, and you should be able to request it
for the day, Ms. Dineski. We'll wait.
Okay.
So if you want to put together the 10 dates or whatever,
I'm pretty sure. What I'm saying is it could save everyone a lot of time if we just address, because they can look it up specifically by address, and you can just literally.
I don't know if they can or not. I don't know anything about their system. I don't know if they can look it up by your name or the address or not. They're not Van Buren. Just because Van Buren does something one way does not mean that Sumter does it that way.
I mean, that's kind of the same procedure at all police stations.
It doesn't, I don't know whether they keep their documentations that way. I want from you specific dates, so I'll wait. So go ahead and give me the specific dates. You're the only case that I have left this morning. So we can wait. Go ahead and I'll put you on hold. Let me know when you got the list. Okay. All right.
Yep.
Just hang out.
I'm going to go ahead and let you know that I have most of these police reports along with the body cam, but that's part of the surprise for part 4. Stay tuned for that one.
Yeah, Mr. Young, we're just going to wait for her list if there are specific dates. If not, it is just for the 8th.
I just spoke to Detective Saligen. There were 2 officers that responded on this date. I'll get the body chest cam from each officer. I'll have that in the next couple of days. I understand there's also a tape that was submitted to the Sumter Township Police Department from the victims that provides some additional information. He's downloading that. So there'll be 3 tapes. I don't know how many reports. I'm assuming 1, but there might be a supplemental report. And 1 week from today, by 10 a.m., I will leave it at the front desk.
Okay. But hang out until I get if there are any other specific dates, if you have police reports on those dates or not. But let's just wait for a minute.
Okay. I can't wait forever, but I mean,
I'm not asking you to wait forever.
I know you're not. I didn't mean it that way. I just meant it. Whatever. Let's just see what happens. Okay.
Hello? Hello? Hello?
Yes.
Oh, sorry. I didn't know I was muted. You guys.
Where are these dates at? You got 20 police reports filed. 20. 20. Not 1, not 2, not even 20.
Had me muted and I was trying to tell you all the dates.
No.
Even that. You had me mute out. It's always this victim. Now they're purposely muting her because she's trying to tell. It just everything. It's a victim. But when she does things, when she breaks the law, when she gets held in contempt, in her mind, she didn't do anything wrong. Because in her mind, everything they're doing is unlawful. So she probably got this sovereign citizen where anytime a statute or order is unlawful, you don't have to follow it. That is taken from the 1800s. It don't work like that today. So she thinks that as long as she believes it's fraudulent, unlawful, she can just do what the hell they want. But when they take actions according to the law with her, she's going to justify now that it's fraudulent what they're doing, and what she's doing is not fraudulent because what they're doing is fraudulent. So she could just do what she want now. What a nut job.
Oh, I didn't mute you. You muted yourself. Anyway,
I don't know how to. I don't even know how to mute myself.
That's fine.
Somebody
Mr.
muted
Nesky.
me.
What are the
You need to learn.
dates?
February 3rd.
Hang on.
February.
Hang on 1 second. And these are all Sumter Townships. It can't be a different department, okay?
Yep, these are all Sumter.
Okay, go ahead. February 3rd.
There's actually one also on, was it the, I believe it was January 19th as well.
January 19th.
And then February 3rd, February 16th, February 17th, March 1st, March 2nd, March 3rd, March 29th, April 5th, April 14th, April 15th, April 29th, May 4th, May 5th, May 6th, May 8th.
Well, the
May
8th only
9th.
include, nope, nothing past the 8th. We don't go past the date of the charge.
Are you telling me that from January 19th to May 8th, you had 16 different police interactions?
16.
Regarding this matter. That's an impressive average of 1 police report per week for 16 straight weeks, including 2 3-day streaks from March 1st to March 3rd, and then again from May 4th to May 6th. Something tells me that if you continue down this path, a lengthy prison sentence is eventually going to extrude itself from one of your many malicious 911 calls.
Did you get all those
Okay.
dates, Mr. Young? If there's any police report on any of those dates, produce it. If there's not, there's not.
I'm only producing police reports.
Yep, that's all you should
Well,
have.
and then on like the May 4th and May 5th and May 6th, there should be body cam footage where they were there at my
On the May
house and they
dates,
were
Mr.
destroying
Young,
my
Ms.
property.
Dineski, please stop. On the May dates, Mr. Young, because it's within a couple of days of the incident, if there's body cam, if there's not, there's not.
It's going to be at a different address than the address that they reported me being at. It's at where they came. The person who lives at the house who said I maliciously destroyed their property actually came to my house when I wasn't there with the police, and the police let him destroy my property.
If there's a
Well,
police
I wasn't
report
there.
from the
Look how ridiculous she sounds. Look how ridiculous she sounds. Look how ridiculous she sounds. Hold on, y'all. I got to get it back. Something happened. Hold on. Let me get it back for a second. Hold on.
sixth, they'll produce whatever in relationships to these parties,
Okay.
Mr. Young.
And that includes the body cam footage?
If there is any.
Okay, perfect.
That's from the 4th, 5th, and 6th. In this incident's the 8th, which I indicated I do have body cam and
For the 8th, yeah. But if they have anything for the 4th, 5th, or 6th that involves any of these people, produce it. Otherwise, just police reports. Can you do that within two weeks, Mr. Young? Can you do that?
yeah, I think you better give me another week because I just knew it 3.
Well, let me give Michelle, what's the next date that I can give her? Michelle, what's the next Sumter date?
10th.
August 10th?
Yeah.
And if you get it to her if you get it to us, how much time do you need? Do you want till the 3rd, 3 weeks?
That's fine.
All right, so Ms. Dineski, you can pick this stuff up on August the 3rd, and then we'll see you again on August the 10th. At what time, Michelle?
At 9:50.
At 9:50.
Okay.
All right,
And
so
then
you can
is that
come
gonna
in
be
to the
available
court
for
on
me to
August
pick
the
up?
3rd. Pardon?
Since I don't have anywhere for you to mail that to right now, am I
You're
able to
bringing
pick
it
that
to
up?
the court, and you can pick it up on August 3rd.
I'm talking about the court date information.
Oh, the court date information, it's the same login. It's with me.
I can email it
And
to
then
her.
I haven't.
She'll email it to you.
Okay, thank you. And then I didn't receive anything about any of the other stuff. Like I never received anything about the eviction. And just so you know, the Sumter police refused to follow your order so that I could go get my stuff, and all my stuff was thrown out from that house.
I don't know what the
refused to let
state,
me
I
go
don't
back to
have
that.
that file in front of me right now. And so when you come in on the 3rd, you can ask for a copy of that file if you want.
I have a copy of the file. What I'm telling you is you gave an order saying that I could go get my stuff, and the Sumter police, this is part of the malicious prosecution I'm talking about. The Sumter police denied your order and denied letting me go to that house to get my things.
And
all my things were thrown out.
I can't deal with that file right now. I don't have it in front of me. So I don't have it.
Well, I filed something on it and you guys wouldn't look at it.
Well, I
filed a motion.
I think it was told, Michelle, you would pause this.
I was told to file it, and I filed it the way that it was supposed to be.
You notice how everything is always this victim. The police just stopped me. She never gives context. I guarantee you, she's the type of person that's going to leave everything out that preceded, then may not allow her to get her stuff. She's going to leave all what she did out. So the only thing that we hear is they just violated the order and wouldn't let me get the stuff. Now, I know that's not true, but since she's a victim and being attacked, there's nothing that she's ever going to admit that she did is wrong. This whole thing, y'all issued a fraudulent warrant. The judge never allowed this. They violated the order. You notice how it just seemed like she's just one big victim machine that everybody just attacking her.
Filed, and I never received any response back saying it was denied.
No, I know that it was.
I need all that documentation.
I know that I had multiple after the file was out of my hands that it was an appeal. Any complaints?
No, I asked for a trial and I was denied a trial, which is a violation of my rights. I repeatedly asked for a trial.
You can appeal that decision. You've been told multiple times you can appeal the circuit court on the landlord.
But why? But how do I appeal? You can't appeal.
I can't give you legal advice. I cannot give.
You said you was going to law school, so.
I'm not asking for legal advice, but the thing is I know legally that I was denied my right to a trial, and I shouldn't have to appeal that.
You can appeal the decision.
You have to appeal it. Oh God.
We're all set for today. Thank you, everybody.
But again, what about how they refuse to give me my things?
You need to come in on August 3rd and pick up those documents, and then we will see you here on August the 10th. All right? You're all set for today. You mean in the Zoom? Yes. But you got to come live on the 3rd to pick up your stuff. All right, everybody, we're done. Bye.
All right, so we finally reached the end of part 1. These appearances are actually quite tame compared to part 2 and beyond.
Oh yeah, it gets horrible. It gets worse. It gets worse and worse and worse and worse. But it's so damn entertaining. Yeah. This is what happens.
$100 billion in valuation in just one day. You heard me. $0.6 trillion was gone.
Scream out in agony. My biggest wish is that God allows.
Discount off the Pro plan. Thank you once again to Venice AI for sponsoring this video. So let's begin.
Dude, my lawyer is 82 years old. My lawyer, Andy Fanta, he's a maverick. Lindsay said to my 82-year-old lawyer, I hope and I pray that God lets me watch as you're cast into the fire and your skin melts from your body and you scream out in agony. My biggest wish is that God allows me to watch you suffer. Blah, blah. Like, she sent that to my fucking octogenarian lawyer. So his hand was shaking. He printed it out and handed it to me, and his hand was shaking. He's like, in all my years of practicing law, I've never encountered such a vile human being. I'm like, dude, I've been getting those texts for 2 years.
Ms. Dineski, please state your name for the record.
But you notice how that she never spoke about that nasty ass text that she sent to an 82-year-old man. You notice that? No respect for her elders. I told you, y'all, these are some of the nastiest, meanest, vilest. It's like it's venom coming out of their mouths. They have no shame. They have no shame, no self-control. They have no morals, no values. No, you know what? I'm not going to say that. I'm not even about to say that. There is no depths or levels that they will not stoop to when they feel like they're scorned or they're not getting their way. And these are the people who we're supposed to protect. And what are you going to do with an individual like that? Who can be married to a person like that? Knowing that the minute things don't go her way, she's going to spit some nasty, vile things out of her mouth. And then when she's not mad anymore, she's going to act like she never said it. And the relationship's supposed to just stay cool. You're supposed to just be her fucking doormat. Give her what she wants. Grow the hell up. You are an adult. Grow the hell up.
All right, parties, raise your right hand, please. Do you solemnly swear or affirm that any testimony you give this court will be the truth and nothing but the truth? All right, very well. So I have a couple of motions in front of me, and I think it's probably going to be best to deal with there's a motion for recusal that was filed by Ms. Dineski. And Ms. Dineski, I'm going to give you an opportunity to speak to that motion, as that's probably a motion that should be heard first prior to the other motions. And that's prior to addressing any matters as it relates to this case on any issues.
Yes.
Mr. Fanta?
Yeah, if I could, Your Honor, first of all, as counsel for plaintiff, I would like to thank Jasmine of the court's office, because we were never served with the response for my motion to strike the pleadings, and we were not served with the motion to recuse and another motion, ex parte pickup for the kids. And kudos to the court's office and for Jasmine in sending copies of those three things to us. I just wanted to place that on the record. And coupled with that, it's my understanding that my office checked Odyssey, and there was a motion filed on the 27th of June, and there were, I think, 2 filings on the 29th of June that we have never gotten what was filed on the 27th or the 29th. And I just wanted to place that as a matter of record before court. Thank you so much, Judge.
Okay. The court officer is my judicial assistant, and she works very hard for the people of the county for which I've been elected to serve in this capacity. So, Ms. Dineski, what I will say is this. When you're representing yourself improper, which is your self-representing, whenever you file something with the court, you have to serve copies or send copies to the other side. And so I'm just going to recommend that you do that, because what happens is if they're not getting the motions timely, then the matters, depending on the position of the other side, could be adjourned. So I don't know what Mr. Fanta's position would be this morning, but I do think it's important that I address your recusal motion. And so I'm going to allow you, Ms. Dineski, to proceed on your motion for recusal.
The reason why I didn't serve the other parties was I was asking.
Oh, so we're not on the serve side yet? Let's deal with the recusal motion first.
Yes, ma'am. So the reason why I was asking for the recusal is because when we had the PPO hearing to have the PPO dismissed that I had filed against Charles Nerswick, I was denied my due process. I was discriminated against by you because I had an illness, and I told you that I had an illness, and I told you that I couldn't take my medicine that was required for me to proceed because of my, I have ADD and I have autoimmune disorders. And so if I can't take my medicine, and I was sick and dehydrated for 3 days.
I'm sorry, but I'm not buying her bullshit. While there are protections under the ADA for people with ADHD, there is no blanket coverage, meaning that you can't just tell the court that you have an attention disorder and expect some kind of guaranteed special treatment.
And I had let you know that I had good cause to have the hearing rescheduled. And so I was not able to, articulate why I needed to have that PPO kept in place. And then you dismissed it. And then I asked, well, before you dismiss it, I'd like my evidence, my actual physical evidence to be looked at. And you refused me a chance to have the evidence looked at. And then because of the dismissal of that PPO, it caused Charles Nerswick to harass me mercilessly. Him and his family terrorized me to the point where I had to leave my home. And I was trying to go to a domestic violence shelter because the harassment, it was like a mob style harassment had happened so fiercely against me and my own.
But let's go back to the text she was sending. Those nasty ass, vile ass texts. Now, remember, nothing what they do is ever wrong. They're always going to be the perpetual victim. You sent those nasty ass, vile ass, evil ass texts to an 82-year-old man. Now you're talking about so much violence and abuse against you. The hell out of here.
Own home, of which him and his family have aspired to evict me from unlawfully. And they locked me out of the house, even though the eviction wasn't complete. They would go in there when I wasn't there and destroy my things. And this was all because of that dismissal of the PPO. And then because of the dismissal of the PPO, he was able to harass me, and he took a fake court order that was vacated by Washtenaw County and lied to the FBI and had the police lie to the FBI to have the children illegally kidnapped from me. And I have not seen them since May 5th. He's been illegally withholding my children, our children, since, or not May 5th, I'm sorry, May 6th, when the order was vacated on the 5th. And none of that could have happened if the dismissal of that PPO would have been heard properly, and I would have been given a chance to defend my position and my stance with my evidence with a sound mind, which I couldn't do when I was so ill and I had the stomach flu for 3 days and I couldn't take my ADD medication or my autoimmune medication for 3 days. So I was not in a proper state of mind to testify. And that was a violation of my rights to have accommodations under the ADA and my right to due process under the 4th, the 5th Amendment, and also the 6th Amendment and the 14th Amendment, equal treatment under the law. So unfortunately, maybe you didn't realize it at the time, but you grossly violated my rights.
I told you, every judge she's in front of, she's accusing him of violating some of her rights. She can't not help herself. It's always somebody else.
It led to the unlawful kidnapping by Charles and his co-conspirators of taking the children, and he's been withholding the children from me illegally and concealing them from me since May 6th.
Well, he hasn't been concealing them, and he doesn't have them illegally. He has full custody of y'all's children because you went full dipshit on him, his family, and the Washtenaw County.
Okay, Ms. Dineski, I've heard your motion. I don't know if you know what the purpose of a PPO motion is. First of all, the PPO motion will be against you and not the children. You did not sufficiently allege facts that indicated that your life was under any imminent threat. And so by you failing to show that, your PPO was terminated. And that was by me. Okay, so
so she just made an order. She made her legal bounds for the order. And one of the clearest indicators that you're dealing with a sovereign citizen is that they always want to answer why their motions were denied. They after the judge gives you a legal reason why, they always want the judge to explain to them, now, why did you not grant it? They all want to know why. The judge is not inclined to ever, once they make their ruling, lawyers and me, we just move on. But you're with the sovereign citizen when they always want to demand why their motions were denied.
And so because you failed to show sufficient evidence that your life was in imminent danger or that there were threats, then your PPO.
And remember, they used the evidence of the ring cam of her pulling up, banging on his door. But then she goes into court saying her life is in danger, when she's actively walking into the so-called danger.
Was dismissed. And PPOs are not to be used to prevent fathers or mothers from visiting with their children, from
which is exactly what she did.
Parenting time. There are court.
Show my evidence. I specifically asked you, ma'am, if I could show my evidence, and I never tried to keep the children from him.
And so as to your motion for me to recuse myself, it is denied.
So why didn't you let me show my evidence?
Told you. Told you. Now that the judge said she didn't provide sufficient evidence, now is you didn't let me show my evidence. You see, it's always going to be an excuse. And I think it's a psychological thing for them, because as long as they can make themselves the victims, then they have a reason, a mental reason not to address the errors of their own ways. Because as long as they're the perpetual victim, then there's nothing about them that they feel they need to change, because they're the victim. Things are happening to them instead of their actions are causing the equal but opposite reactions. So when you notice, when you deal with people that are victims, that are perpetual victims, that's one of the common denominators between them being the victims, is that they never change their actions.
You said I failed.
So I responded to your motion. I've denied it.
Well, I would like to know why you were.
There you go. And most likely, you're dealing with a sovereign citizen.
You think that it's.
I just stated on the record.
Can we get the recording of that court proceeding so you can see?
It is available to the public. It is available to the public, and so you can obtain the recording. Your mouth is moving, Ms. Dineski, but we don't hear anything. I don't know if you have an issue with it. Appears you have an issue with your sound, because you're not muted, but your mouth is moving that I'm noticing, and we can't hear anything that you're saying.
Oh, I'm sorry, Your Honor, but she isn't actually talking. You see, sometimes her brain decides that she's said enough, but her mouth just never gets the memo.
I said, ma'am, you refused to allow me to show my evidence. So it's not fair for you to say I did not show evidence when I had evidence submitted and you refused. You literally refused to look at my evidence. And on top of that, I was not competent to stand trial, and I had good cause for a continuance of which you denied me under the ADA Title II because of my disabilities. I could not take my medication, which affects my neurological and physical ability to put my thoughts together, because I have ADD due to a head injury as a child. And so I was dehydrated, I was sick, I couldn't take my medication, and I could not competently state my case that day because of my illness. And you did not give me the accommodation that I was required under the law, and you refused to allow me to submit my evidence that would have proven my case. And then you dismissed the PPO in violation of my rights. And just for the record, I never used the PPO to keep the children from the father, who he hasn't even established paternity yet.
Ms. Dineski, that's what you represented to this court. You represented.
Well, like I said, I was
the PPO to prevent Mr. Nerswick from.
No, I did not. I never did that. I did that for my own safety. I didn't even add the children on there, except for that he couldn't take them without a court order.
Oh, okay. So you weren't denying him an opportunity to see his kids. You just weren't going to let him see them unless he went to the court to get an order forcing you to do so.
Y'all, if y'all not getting notifications, please hit the bell, turn it off, and turn it on. I don't know what's going on with YouTube, but I'm looking at my analytics for this live that I'm on live now, and it says, I don't know, right now that I'm on now, real time, 157 views. Right, that's what it's saying for the new culture reviews, portrayed, this live that we're on now. It said I had 157 views. but this live is still going on. So I don't know if 157 people came in and out. I did see on my StreamYard, it got up to like 20, but I don't know where the 157 views came from. So I don't know what's going on with YouTube.
And that was what I was told to do by the people at First Step. I represented that I was scared of him due to his attack of me. I had pictures of the bruises. I had witnesses that show that wrote affidavits leading up to it, and all of my evidence.
I've made my decision.
Well, then how do I appeal that? Because
so the court does not give legal advice. Okay, you're representing yourself improper. And so you're held to the standard of a licensed attorney of Michigan.
Actually, I'm not. That's not what the rules of pro se.
I would not give a lawyer legal advice on how to do a case. So
well, I'm not asking
that being said,
advice, I'm asking for what my recourse is.
I've made my decision.
And why did you make your decision, for the record? I've
already stated it on the record. Mr. Fanta, you may proceed on your motion.
Thank you very much, Your Honor. And again, for purposes of the record, I really want to compliment the court and Jasmine Castro on this matter for her sensitivity in sending us responses that Ms. Dunsky has filed. Otherwise, we wouldn't have them. Your Honor, I have a motion.
Mr. Fanta, to proceed on those today. I don't know when you received them, but are you prepared today for those?
Well, no, I'm not, Your Honor. What I would very much like to do is, I'm conscious of the court's time. I have filed a motion to strike defendants' pleadings in response to the complaint that we filed for custody on May 15th. And I would just highlight for the court number 4, which has a number of different subsections to it. She responded with 15 pages of allegations against my client in a haphazard and disorganized manner. Allegations that and a request for a guardianship, and they're all enumerated in item number 4. And she concludes then finally that the plaintiff is not the biological father of the 2 minor children. So it's an
I never said that, sir. No, I did not. I said he has an established paternity, so please do not lie and misrepresent what.
Notice how she's cutting off the other side. Whether if a lawyer was to do that, they would be sanctioned. They would be sanctioned without no doubt. See how disrespectful this person is?
I've said.
You're misrepresenting what you said. And it takes a special level of retardation to convince yourself that requiring him to take a paternity test is not the same thing as accusing him of not being the biological father.
Ms. Danunsky, I will give you an opportunity to respond, but you have to let Mr. Fanta complete his.
Well, I object to dishonesty. So if he's dishonest, I will object. But I object to what he just said.
But as you can't.
Dishonesty is not a legal reason for an objection. You have to have a legal grounds for objection. It's under rules of evidence. See, you learned this when you learned the court rules. You can't just object because you don't like what you hear.
You can't object to what someone has said unless you state a basis. And
I just did. It was a lie. You can look right at the paperwork, and I did not conclude anything. I said the only thing I concluded was he is not determined paternity.
So objections have to be as to the rules of evidence. And so you have to know.
What did I just say?
The court rules of evidence in order to do an objection.
Well, you can instruct me as a judge because I'm a pro se litigant, and you can instruct me in procedure according to the rules.
So I do not give legal advice. I'm holding to the standard of a lawyer today. Okay.
Well, and that's a violation of my rights. Because
no, it's not. When you proceed in pro se, in persona propria, in purporta, how y'all like to call it, or how they like to call it, you are being held to the same standard as a lawyer. This is why, if you don't know the court rules or know the procedure, you need to get a lawyer, or in the alternative, because that's a legal term, or in the alternative, you could join the SETU, Supreme Elite Team University.
You're rocking with the best.
Let's proceed.
You're
I'm not held
choosing
to the
to
same-
represent yourself improper. And so
Pro se. I'm pro se, not pro se.
you are not going to be able to interfere with what Mr. Fanta says again, or this court is going to hold you in contempt. And so I am warning you, Ms. Danuski. Mr. Fanta, you may proceed.
Thank you, Your Honor. I would appreciate it if the court would honor my motion to strike, give what the court thinks would be a reasonable time for the defendant to answer the complaint for custody, instruct the defendant that on the pleadings, in addition to the case number, counsel is to be listed with his name, address, and email and contact numbers, and that a proof of service that we have received the response, the answer to our complaint. Secondly, I would like to have this honorable court issue an order of temporary custody for the children.
So everything he just said, according to the rules, basically he was every state law court rules are kind of virtually similar to the federal rules. So basically he was talking about Rule 8, Rule 9, Rule 10, Rule 11, Rule 12, and Rule 65. Those are the 4 rules he's talking about right now.
For Mr. Nerswick. In Exhibit B, which is attached to the pleadings that we filed, is a detailed statement, review, and recommendation from the Washtenaw County Circuit Court, friend of the court.
That's inadmissible. It was from a vacated order. I object to that, Your Honor. According to the rules of
You
evidence.
will get a chance to respond, Ms. Danuski.
So should I just write down my objections? I thought you object as they
Yes,
come up.
no, that's not how that works. Not under these circumstances. This is a case management conference.
I guess I'm not really surprised anymore when people whose entire legal education comes from YouTube videos don't understand proper court procedure.
Mr. Fanta, you may proceed.
No, they don't, Team Skeptics. They have no clue.
On the friend of the court, I'd like to know more about that order.
Yes, Your Honor, if I could sketch a bit of background. When Ms. Danuski filed the PPO against Mr. Nerswick, the one that this honorable court dismissed, Mr. Nerswick followed my instructions to the letter, did not go near, wasn't in the vicinity of the premises, and stayed away. He bunked with friends in Washtenaw County. And after the county residence was established by him, we filed a complaint for custody in Washtenaw County.
Mr. Fanta, I'm sorry to interrupt. I see 2 PPOs here. Let me.
Well, Mr. Nerswick filed a PPO against Ms. Danuski.
Oh, I see it. And so the PPO that she had, 23-100812.
That was heard by this honorable court and dismissed by this honorable court.
I understand. What is the status of his PPO against Ms. Danuski?
It's still in existence.
Okay. All right. I see it. I'm sorry. You may proceed on the more information on the family court matter. I'm sorry. Go ahead.
Yeah, thank you, Your Honor. I understand there's a lot of balls in the air on this case. Basically, he had an order for the kids, and we worked with Sumter Township in trying to obtain the kids from a lawful court order.
So let me ask you this. I'm going to ask questions. So there was a Washtenaw County order, and is that order still standing? It's still in place?
The Washtenaw County case was dismissed, Your Honor. That's why we filed the case before Your Honor, in Wayne County. He got the custody of the kids from the Washtenaw County.
So what was the basis of that case being dismissed in Washtenaw?
There were 3. If you would like, I sent you a letter.
No, it's not your turn. Mr. Fanta, are you able to give me that information, or your client is under oath and he can give it to me too?
Well, that would be fine, Your Honor. This case is massive in its exhibits. I have an exhibit there. I'm just going through it now.
Mr. Nerswick, can you give me, so if a case is dismissed, I mean, yes, it appears that Mr. Nerswick had the kids based on an order that was out of Washtenaw County, but without me getting an understanding as to why that case, Ms. Dunswick, not your time, it's the plaintiff's time. I'm going to come to you, okay? Okay, so had you served her personally with a process server, Mr. Fanta?
Yes, she had proper service on the Washtenaw.
Go ahead, Mr. Fanta. I'm going to mute her until it's time for her to speak. Don't unmute yourself, Ms. Dineski. Go ahead, Mr. Fanta.
Yes, she had proper service of the Washtenaw County case. I'm trying to get the person here. Just give me a second, Your Honor. I'll try to find.
So it wasn't dismissed for improper service, but
no.
It was dismissed for something. And I guess the thing is, there's an order that was in place, and then the case gets dismissed for an unknown reason. And both of you are here today in Wayne County. Now, Mr. Fanta, is your client a resident of Wayne County?
Yes, he is, Your Honor.
All right. And so I am going to allow Miss Dineski to speak. So, Ms. Dineski, you may unmute yourself and you may speak to what has been said. Now, what I do want I want to specifically know, why was the case in Washtenaw dismissed?
I did send the copy of what I had sent to the court to you guys via email this morning as to why Judge O'Brien vacated the order. There was 3 points, of which it was
hold on 1 second. Let me pull the order.
It was found to be void. And I think I sent you the order as well.
Hold on. Did you send it to Mr. Fanta?
Well, he has a copy of it as well. Yeah, when I sent,
I'm going to ask that you email it to Mr. Fanta right now. So
yeah, he had a copy of it originally when I first sent it to the judge. I think you can see he was copied on it.
Okay, I don't think he has it right now. And so what I want you to do is I want you to email it to Mr. Fanta right now.
Okay, got it.
I don't have any of the Washtenaw County case with me here.
I don't have the email, Ms. Dineski.
Oh, I'm
How did we
forwarding it to, like, I'm forwarding it from where I sent it to you.
She sent an email at 8:14 a.m. It was 2 of them.
Okay, did you send it to Mr. Fanta?
I'm trying to find his email in here. Hang on 1 second.
Okay, so this is what I'm going to do today.
Here we go, the law shop. So the court order was vacated due to fraud upon the court, lack of jurisdiction, and improper service. And
okay. I think where do you live, Miss Dineski?
I was living in Belleville at the time, and so the kids were living in Belleville at the time, and so the case should have been filed in Wayne County, but because I had the PPO, he lied about his address to get it into Washtenaw County. But even if he had been in Washtenaw County, it goes by where the kids were living, and we were living in Belleville at the time. So
okay, so here, well, let me ask you this: where were the kids? What was the well, let me ask you this. Before the case was filed in Washtenaw County, where were the kids?
With me.
Mr. Fanta.
So the lawyer.
Mr. Fanta, you're muted.
Yes, Your Honor.
This is what I want to do. This is what I do. I do parenting time. orders at case management. Okay, I'm going to refer this case to Fame. But because it takes a while for the court dates to come, I'd like to have a parenting time schedule in place. So was there regular visitation with how old are the kids?
3 and 4.
And was there
And he's been withholding them from me for 2 months now,
Ms.
ma'am.
Danaski, hold on.
No, I want to file charges against him for parental kidnapping.
But that's not where this is not where you do that. Okay.
Well, the police will not help me. So this court is.
So hold on. So Miss,
I would get a chance to talk.
Ms. Danaski.
Well, ma'am, you said you'd give me a chance to talk, and I have not.
But that's not what we're doing right now. Okay.
Well, I would like to see my children. I haven't seen them in 2 months.
Ms. Danaski, were there regular visits with Mr. Nurswick prior to the filing of the Washtenaw County case?
He refused to see them. He refused to talk to me about them. I contacted his lawyer, which I also sent you the emails.
I'm saying prior to the Washtenaw filing, you said the kids were with you.
They were with me, and I tried to get him to talk to the kids. I even contacted his lawyer to set up facilitation of him talking to the kids through, because I had the PPO, and I was not trying to keep the kids from him at all. I wanted him to have communication with the kids, and he had showed no interest in communicating.
Okay, Mr. Fanta, your response to that?
Your Honor, everything that Ms. Danaski has just shared with the court is not factually based. It is blatantly untrue.
So tell me, Mr. Fanta, why I should not put a parenting time order in place.
I sent you the email
until you all go to Fame.
If I may, Your Honor, when we filed the Wayne County case, we were conscious of the parenting time needs, and my client and my office paralegal met with Sumter Township. We tried to work with them so that we could have parenting time. Hanging over this case is a South Carolina case, 2018 DR-233056, where Mr. Kenneth Danaski, a former spouse of the defendant in this case, was awarded custody of their 2 children.
Damn, Lindsay, you're 0 for 5 when it comes to mothering children. Maybe it's time for you to pick up a new hobby, like competitive window licking.
There is a court order from that case holding her in contempt with a 6-month jail term, and that is Appendix E in my pleadings that are filed with this honorable court, and she took the kids and fled to Michigan.
Damn. Now, he put up some hell of a case law. Now, watch. Let's see how none of that's true. It's a conspiracy, and the judges and the police conspired against her. Let's just see.
I absolutely did not. That is a lie. I object to that. That order is actually a void order as well.
So here's where I
told you it's a void order. I told you any rulings, orders of the court that doesn't go her way, in her mind, she could just ignore them. In her mind, all orders that are not 100% in her favor are void. That's how she thinks. That's her version of what the law is. If it doesn't comport with what I want, then I don't have to follow it.
I'm making a decision today. Mr. Nurswick is here today. He's hired counsel today. Mr. Nurswick has been at all court appearances.
So have I.
I'm going to refer. You have.
So can I please see my children? There's absolutely no reason for me to not see my children.
What was just represented to me.
But that isn't true, ma'am. I have a right to defend that.
And not only that, your words indicated that you were filing a PPO to keep Mr. Nurswick from his kids.
No, I was not, ma'am.
And so there was not.
No, ma'am, I did not.
So here is what we're going to do.
Ma'am, excuse me, can I please have my due process and say, I sent you an email this morning this morning.
Yeah,
that
but
I
you
had-
An ex parte email. You cannot send ex parte communications to a judge because the other side has a right to see and hear and review any communications that goes to the judge. So if you send her ex parte communication, one or two things are going to happen. Either they're not going to read it or they're going to immediately forward the communication to the other side.
did not send it to Mr. Fanta. He did
Yeah,
not.
it was an email.
So
between
Mr.
us.
Remember, she said you did not send it to Mr. Fanta, so he didn't get it. You didn't CC him, so that's called an ex parte communication, which is if she was a lawyer doing that, she could have got sanctioned.
Fanta,
No,
I'm going to
ma'am,
give you
you're
an
not listening.
opportunity.
Because all you about to do is lie. You about to say how that judge, how that order was voided because it wasn't true. So that means I had the right to do what I need to do. So just shut up.
To review
It
everything.
was an email I sent to
that
Mr. Fanta, ma'am.
Ms. Dinansky has supplied this court with. The court is just getting an email this morning at 8:14. And so in the meantime, while the court is reviewing these motions that are supposed to be submitted to the court timely, not the day of, then
They're not motions. They were just
send you all, you can't send anything to this court that's not sent to the court time. Because
Well, what I'm saying is that
I
the
have-
letter that I had sent was a letter that I sent to Mr.
So,
Fanta
Ms. Castro,
showing that I
I'm
had
re-
goodwill. I never tried
No.
to keep my children, ma'am.
I am doing an order. I'm referring you to Fame, Mr. Fanta.
Yes.
I'll get an order from Miss Jasmine Castro, my judicial assistant.
There has to be a good reason for you to keep my children from me, and there is absolutely no reason. I have been their sole caregiver since birth. They were ripped away from me illegally based on an order that
So
the
you'll
judge.
get a referral for Fame.
But why
and
I need to see them
I'm gonna
now.
give you
I have
another
a right to
court date.
see. They have literally kept my children. The Sumter did not
Your
work.
request motion to strike is going to be held in advance. I'll take a look at that, Mr. Fanta, the next time you come, okay?
Thank you, Your Honor.
In the meantime, I have to send you all to Fame. And the children.
Your Honor, I would like to state that I've never.
You haven't seen your kids because of your actions. It's not because it's a wild grand conspiracy. It's not because the police department is just, everybody's just out to get you. It's been your actions which have prevented you from seeing your kids. It's been your actions, but in your puny little mind, nothing is ever your fault. Everybody is doing things to hurt you. You don't take no accountability for your actions. You have caused all the things that are happening to you has been because of your own actions, and you don't even realize it because in your mind, it's everybody else's fault but yours.
Never kept to him from the children, and that email that I had sent
I'm
this
gonna
morning,
give you
ma'am,
a
was me
date.
showing that
As
I
soon as,
wanted him to see the
my
kids.
clerk gives me a date as soon as she.
So I don't understand why you're saying that I used the PPO to keep him from the kids. I never did that.
That's what you said.
No,
That's
I never
what
said that. When did I say that?
You said, you said as a result of your PPO being terminated by me, he came and got the kids.
No, he came and harassed
here.
me. That's
He's
not
with
what
the
I said,
lawyer.
ma'am. You are I never said those words.
Okay, well, you know
What
what?
I
We're
said,
still
ma'am.
going to Fame so that this court
I don't
can
know
find
what
out
Fame
what's
is,
going on.
but the
Fame
thing is
the Family Assessment Mediation and Education Department.
So
You're
will I
referred
be able
there.
to see my children? They have been withheld illegally from me in violation of 750.350A for 2 months.
The judge awarded the kids to him.
I haven't seen them. I haven't talked to them. He won't communicate to me about them. He won't tell me how they are. He won't tell me where they're at. That's illegal. That's a felony crime that he is committing, and this court is responsible.
The FBI had to run you down to get the kids back. Stop it. Nothing has been done illegal to you.
Responsible to stop that crime from and violating my parental rights when I have not been found guilty of any crime. I've not done anything but be an excellent mother. He has been abusive to me. And what I said was, I left the house to go to a domestic violence shelter, not to keep him from the children, but he was terrorizing me because you dismissed the PPO unlawfully. That's what I said. I never said I filed a PPO to keep those children away from him. As a matter of fact, I have proof in phone calls and emails showing that I made goodwill effort despite the PPO. And I have text messages to him saying I want you to be able to speak to the kids, and he refused. I said we could go to mediation. He refused.
Yeah, let's talk about that for a second. And I want to ask you guys something real quick. What do you think would happen to a father who ignores a court-ordered PPO that was put on him because the mother wants him to see his children? Yeah, that's a setup to be arrested for violating a no-contact order. And Chuck, I know you watch these videos, so I want to tell you something real quick. You did the smartest thing possible by ignoring her despite wanting to see your kids more than anything in the world.
I asked his lawyer, does he want to talk to the
Well,
kids?
you're about to get the opportunity to go to mediation now. I'm about to mute you, Mr. Danesky.
So,
Your Honor, if I may, the only thing.
What time? Hold on 1 second. Let me get a date.
September the 27th at 10:45.
So she's saying September 27th at 10:45. Okay, you may.
in the meantime, though, when can I see my children? They've been withheld for 2 months illegally. And that is a
So what
violation
I'm
of my
going to-
parental
what I'm
rights. So
going
can I
to
see my
order-
kids this week?
Mr. Fanta, I am going to order supervised visitation through GrowthWorks.
Why do I have to have supervised visits, ma'am? There has to be an actual legal reason. There's no lawful reason for me to have
She
supervised
can
visits with
Visit
my
with
children.
the kids once a week, supervised visitation.
So
through
why do I have to have supervised visits, ma'am?
So you won't take them and run off with them because that's part of your plan anyway. That's why you're mad. If you really want to see the kids, you just see the kids, whether it's in the zoo, whether it's at a park, whether at the police station, supervised, whatever. You really want to see your kids, you can see your kids. But you have ulterior plans. You're sneaky, you're conniving, and all of your fake little outrages, no one's paying attention. The courts don't care. They're seeing right through you. As soon as you wake up and see that, maybe you'll come back to planet Earth.
You need
Castro,
to give
did
me
you
a
get
lawful
that?
reason.
Your
I need
Honor,
a lawful reason why I'm being,
Your
I'm
Honor,
having my parental rights obstructed.
Go ahead, Mr. Fanta.
yes, Your Honor, counsel would suggest that when this honorable court has a moment off the bench to work with the judicial officer, Ms. Castro, and look at appendix.
Actually, this case needs to be dismissed. As a matter of fact, this needs to be dismissed immediately because he's filing with unclean hands.
Go ahead, Mr.
He's filing, ma'am, I forgot to say, when you said I was going to have a chance to talk, this case needs to be dismissed.
But she keeps unmuting herself. She can't. She just can't shut up. She just can't shut up. You know, I've never seen a case where a man acted like this. And all I do is study case law and watch court cases. I've never seen a man do this. I've never seen a man come into court this conniving, 100% lying. And I've watched hundreds and hundreds of hours of videos. I've never seen a man do this. Never. Never on camera. Not saying they haven't, but I've never seen cases where men acted like this. Never. And I watch hundreds and hundreds and hundreds of hours of court cases. Parental, parent custody, all that. I've never seen a man act like this.
Because he has filed it improperly. He hasn't established paternity yet. So this can't even be filed. And he
How disrespectful she is. He hasn't established paternity. The father of your children. You keep throwing that out there as a ruse to get the kids, but you're implying that those kids may not even be his. Look how you don't even, and they don't care how they sound. They'll say and do anything when their backs against the wall, when they're mad. You're talking to this, saying that you keep saying that shit, implying that the kids are not even his. You keep throwing it out there. Like this woman, it done lost her mind.
he's filed with unclean hands.
Mr. Fanta.
Can we please talk about the dismissal before this goes to fame?
Your Honor, I think the court has an idea of what plaintiff and plaintiff's counsel has been dealing with as this case has evolved. And the only thing we accept the court date of September 27th at 10:45 back here before this honorable court. We accept the referral.
I don't accept it. This needs to be dismissed
Like anyone gives two fat fucks.
immediately.
It's very difficult for counsel to,
Well, you've had a chance to talk, and I was told I was going to get a chance to talk, and I did not. I got a chance to talk for 30 seconds, and which is why
Mr.
I'm interrupting, because my
You
due
get the
process,
supervised
again,
growth works every week.
ma'am, I would like to know a lawful reason why this is not being dismissed based upon the fact that he
Mr.
has not
Phantom,
established,
did you
he
hear
has not
what I
established
ordered?
paternity.
I'm
I
sorry.
do not consent to the jurisdiction of this court. This needs to.
Look, she in full desperation mode. You've been in our proceedings for almost an hour. Now you want to bring up jurisdiction. Told you they'll do and say anything.
Be dismissed.
Mr. Phantom.
On the rules of Michigan rules of procedure.
Mr. Phantom.
Yes, Your Honor. Again, if counsel could summarize for the court, we accept the court's date of September 27th at 10:45. We obviously accept the referral to FAME. We accept a weekly supervised visit with GrowthWorks. And I understand the court in deferring a hearing on my motion to strike, although I think it would be in the interest, Your Honor, and I do think you have enough evidence to strike her response so that when we do meet on September 27th back before Your Honor, we do have an answer to the complaint for custody that comports with the court rules. That's the only suggestion.
And you're correct, Mr. Fanta.
Well, I can have it served to him if that's what needs to be done, but I want to quote.
So I'm going to.
Oh, you can strike it, Judge. Just strike it. It's a bunch of garbage anyway. Just strike it.
Right.
116.
I'm going to grant you your request. Ms. Castro, if you can issue an order granting his request to strike the pleading that she has submitted. And so that's done, Mr. Fanta.
Thank you very much.
I'm requesting, according to Rule 2.11.
Go ahead, Mr. Fanta.
The only other thing.
When am I going to get a chance to talk?
What the?
You haven't stopped talking. You haven't stopped talking. And you're not making no sense when you talk.
What have you been doing this whole time, Karen? And if you had even the slightest modicum of what it means to be an adult, then you'd understand that the best conversations happen when only one person speaks at a time.
Mr. Fanta, you're going to have to continue to talk. Don't stop.
Thank you, Your Honor.
That's how bad it's gotten. When the judge has to tell me, yo, you just got to just keep talking. Like that's how look how embarrassing that is. Good God Almighty.
Thank you, Your Honor. Very briefly, I'd like to have you sign an order that has been submitted to this honorable court for temporary custody for plaintiff. Everything
I'm
else.
motioning for a dismissal, Your Honor.
No,
when I will have a chance to be heard on that.
Mr. Fanta, I'm not going to do a temporary.
I would like a chance
for custody. I need
after he's done speaking. Will I have a chance?
I need an order. What I typically do is parenting time, and then when you all come back, I'll have a recommendation from Fane.
Ma'am, will I have a chance to assert my dismissal?
I don't really have a basis. Well, this court is not satisfied. I understand, Ms. Dineski.
You have to give me a chance to present that.
She's very rude, but I need a.
Ma'am, I am not trying to be
mediation
rude.
To do a family assessment.
I would like to be able to have my due process.
So I don't do.
Ma'am, that's asserting
orders at case management. I'm not even temporary. Did you hear what I said, Mr. Fanta?
I was able to glean that, Your Honor. Thank you so much. We will abide by the court's rulings.
I would like to.
And so.
I would like to be heard on the.
Just won't shut up. She just won't shut up.
Let me think about.
The judge already says not dismissing it. Why you keep asking for it? Just shut up.
For a second, because I want.
This case should be dismissed, and I have a right to be heard as to why.
I'll submit an order for temporary sole legal and sole physical custody, Mr. Fanta. I will grant you that.
Your Honor, you should have.
Why is that being granted? Because
you won't shut up.
I have a right to.
And so, but I do want the visitation every weekend, the kids visiting and readily available to visit with Ms. Zuneski every weekend at GrowthWorks.
Absolutely, Your Honor. And I think we did submit an order
So
that
if you submitted it, you can reach out to Ms. Castro, make sure I'll have it, and she'll get it to me the way that we do in this courtroom for me to sign, okay?
that would be fine, Your Honor.
I don't sign those orders prior to a hearing, prior to at least your case management, because I'd like to know what is going on the case prior to signing any orders as it relates to anything that is sold. If it's joint, then yeah, you can get those signed. If it's joint legal,
Your Honor,
physical, then I'll sign. But I'd like to have an opportunity to have a hearing on matters before I do that. But I will sign your temporary sole legal and sole physical custody.
Your Honor, I would like to be able to present.
Judge, but Judge, I understand you're doing the temporary, but God damn it, Judge, you don't see this? Like, you should have gave him more than just temporary. Just get to until the end of the proceedings. You should just gave it all the way to him. Like, come on, Your Honor, you see what you're dealing with.
Present my case for dismissal, present my motion for dismissal, because this was filed improperly. So may I please have a chance?
Your response to the answer is not adequate and not accordant.
You didn't give me a chance. I would like to read what I have here. I have a right to assert my case. Why are you denying me?
So
this is why I asked for a recusal, because you're denying me due process. You denied me due process in the last case.
So there are certain procedures that you have to follow.
Excuse me, ma'am. I have a right to speak.
No, you have the right to remain silent, even if you lack the ability.
And so
I can motion for a dismissal at any point during this hearing, and I am now currently motioning for a dismissal. And I need a lawful reason why my dismissal, my motion for dismissal is being
Zuneski, do you have an email address?
Actually, that's not true. Yes, you can motion for dismissal as you've been doing the whole proceeding. The judge denied your oral motion, and they don't have to explain why they deny it. If you don't like the reason why the judge denied it, then this is where you can appeal the decision. That's how the legal process works in the real world.
That you can put in the chat. Do we have her contact information?
I would like
your email address.
2.116 says that I can motion for a dismissal at any time. And I motion that because of fraud upon the court, and I motion for a dismissal based on he has not even established paternity yet. There is no paternity established, so he cannot, there is no, the party asserting the claim.
Look how disgusting she is. She keeps saying that stupid shit. Look how disgusting this woman is. She keeps throwing that out there as a last ditch effort, but you're implying that he's not the father of the kids. Like you would, like they will say anything out of their mouths. Why you keep saying that stupid stuff? That is disgusting.
Legal capacity to make the claim. This court does not have subject matter jurisdiction over this case because he's coming to the court with unclean hands, where he lied to a court, which you can contact Washtenaw County Court and verify that they vacated the order. They vacated the order because of he lied and because I showed proof that he had tampered with my mail.
Put your email address?
There's no information.
Oh, we
you
don't
guys have my email address. But
we do not have any information for you, Ms. Zuneski. I need you.
Well, the opposing party has failed to see the claim on which
the
the
court
granted.
is
So
asking
this
you
needs
to put
be
your
dismissed.
email address in the chat so that you can get notices.
I don't even know where the chat is.
Tap the screen and press chat and put your email address in there.
So I would like to know a lawful reason why, based on what I'm saying, why this is not being
your email in the chat. Have you figured out how to do it, Ms. Zuneski?
I'm typing it in right now.
Please do.
Your Honor, if when we leave the honorable courtroom, if I could connect with the court's judicial attorney, Jasmine Castro.
We'll do that when we get off the docket later this afternoon.
So I would like you to entertain my motion for dismissal, and I would like you to hear what I have to say, and I would like to have my due process. So I would like
to be allowed to visit with your kids every weekend at GrowthWorks.
Well, I want to know why I have to have supervised visits. There's no reason. You have no reason to make
as well as you are being referred to Fame.
So, ma'am, excuse me, I would like to have my right to due process heard with this.
Custody, I will sign the order.
If he has not established
I will
paternity,
submit
how
it,
can
Your
he be
Honor. Thank
allowed
you.
to file for
Okay, thank
custody,
you.
ma'am?
This meeting has concluded.
Ma'am, are you going to continue to deprive me of my due process?
This meeting
I'm
has
motioning for a dismissal. Can you please give me a lawful reason why?
Thank
Can you
you,
give me
Your
a
Honor.
lawful reason why you're
Recording
not allowing my
stopped.
dismissal?
Yeah, I can. The court doesn't have to grant you a dismissal just because you keep talking over everyone and demanding it. And there's a couple of things to note here. At the end of this hearing, Judge Triplett reestablished the sole custody that was granted to the father by Washtenaw County. Also, Judge Triplett struck her motion to dismiss, which was also her answer. So she hasn't legally filed an answer yet, and that's going to come back to bite her in the ass.
Recording in progress. This is case number 23-105-109-DC in a matter of Charles Nurswick versus Lindsay Danusky. Counsel for plaintiff, your appearance.
Yes, good morning, Your Honor. Andrew Fanta on behalf of and with Charles Nurswick.
Okay, Ms. Danusky, please state your name for the record.
Lindsay Danusky.
And Mr.
Danusky is how you pronounce it?
Danusky?
Yes,
Okay.
ma'am.
I'll work really hard at pronouncing it correctly.
You can just call me Lindsay. I don't care.
Miss,
because that won't be proper.
Mr. Nurswick, please state your name for the record.
Charles Nurswick.
Okay, would the parties please raise your right hand? Ms. Danusky?
Oh yeah, hang on one second.
Okay.
You know how they always say that the man is the problem, the man is the problem, the man is the problem. This case right here, I can honestly say with good faith, this woman is absolutely 1000% the problem from top to bottom. She is 100% the problem. It's not him, it's her. She is the problem. If a woman or any man or any individual cannot even contain themselves in the most professional settings you will ever find yourself in a courtroom, and you can't even control yourself in the courtroom, everybody else in the real world, you ain't got nothing coming when it comes to those people. You ain't got, if you can't control yourself in the courtroom, it's a wrap.
You solemnly swear affirm any testimony you give the court today will be the truth and nothing but the truth?
Absolutely.
All right, you may put your hands down. Mr. Fanta, we received your affidavit of parentage for the 2 minor children, and that has been filed with the court.
Why did I not get a copy of that?
Well, this was already filed with the court, an affidavit for parentage.
And that is actually a custody order saying that I have custody of these children. So that's fine that it's been filed, but I was not notified that this was filed.
Well,
and this case needs to be dismissed because there's no standing. And I am suing you in federal court and in the Court of Appeals, and your judicial immunity is waived because you have no jurisdiction to be hearing this case, because he did not establish paternity with an order of filiation before he filed this case. And not only that, even if he had filed an order of parentage or an order of filiation, because he kidnapped the children illegally and went to another court and lied about where he lived to get jurisdiction moved and stole my court documents to make sure I didn't know when the court hearings were. And then he ordered that was so he has unclean hands because he's in violation of the law. So there's no standing for this case to move forward, and it needs to be dismissed immediately. Furthermore, I motion to strike Andrew Fanta's all of his testimony.
Mr. Nancy, he signed the birth certificate. He was at the hospital.
It doesn't matter. That does not what does Michigan law say about that?
All because you want things to go your way. So you're basically just going to keep saying, basically implying he's not the father. Like there is no depths. These people will, women like her, there is no depths that they won't go to. Like there is no charter, no territory that there's just no limits that they won't go to. Like just soulless, shameless, but always the damn victim of something.
That he's still, even if he's on the
he was there. You all were together. He was.
Doesn't matter. It doesn't matter. He still has to establish.
And he signed the birth certificate. So when he signed,
and what does Michigan law say? What does Michigan law say about establishing paternity before filing a case?
Well, it's funny you should ask, because I looked it up. And according to MCL 722.7142, an action to determine paternity shall not be brought under this act if the child's father acknowledges paternity under the Acknowledgement of Parentage Act. What is the Parentage Act? Well, for that, we head to MCL 722.1004, where it states that the Paternity Act is a signed acknowledgement that establishes paternity, and the acknowledgement may be the basis for paternity for court-ordered child support, custody, or parenting time without further adjudication under the Paternity Act. So in a vacuum, Lindsay Dineski is right. Without an acknowledgement of parentage, paternity must be established before a paternity case can go forward. But if there's anything you know about me, it's that I bring the receipts. So on screen, I have the acknowledgement of parentage signed by both the mother and the father for both of their kids. So at this point, the court can ignore her demands because parentage has been established by her.
There's an
improper.
You idiot. Now look at you. Look at you. Look at you.
Case with no standing.
And so the state of Michigan,
we need to have a separate paternity. This needs to be dismissed.
Vital records and help has been submitted. State document of affidavit of parentage has been
submitted. And that establishes his responsibility to the children. And you should know this as a family court judge. It's pathetic that you don't know this, quite frankly. And you're supposed to establish paternity. He has established responsibility. He took responsibility for those children. That's all the affidavit of parentage is.
So you're trying to, so now that you're not getting your way, now you want to say that basically you are implying that the kids are not his.
Look at Michigan law. I put it in the pleadings that I submitted.
I'm going to mute you if you do not allow Mr. Fanta.
In the motion to dismiss, I detail.
Go ahead, Mr. Fanta.
Thank you.
I object to testimony by Mr. Fanta.
Is there any way that she can stay muted?
I object. I object to him testifying on behalf of Charles Nerswick. It's hearsay. Who went to Tinsley, Argo.
Ms. Dineski, I have not filed you in contempt or.
I have to actually do something illegal for you to
you are disrupting these hearings.
These hearings shouldn't be going on. They should be dismissed right now. They should.
Ms. Fanta, Mr. Fanta, what are you
pursuant to Michigan law.
All right. Ms. Dineski has muted herself. Finally, Mr. Fanta, how would you like to proceed today?
Well, if I may, Your Honor, I will try not to try the court's patience in this matter. Basically, I'd like to give the court a quick overview. Concerning parenting time, visits at GrowthWorks, there have been 4. The first one.
Yeah, the ransom. My kids are being held hostage. I object to this, GrowthWorks. And you guys have kidnapped my children. You're holding them hostage and you're charging their ransom.
Is it your point, Mr. Fanta, that Ms. Dineski has not participated in any of the GrowthWorks?
No, Your Honor, I was in the process of giving you an overview of the GrowthWorks visits.
Okay.
For I was interrupted.
And I motion to strike. I object because he is not allowed to present evidence via the Supreme Court ruling Tinsley v. Parley-Argo. I motion to strike everything he's saying.
Mr. Fanta.
He's not allowed to present evidence, so I motion to strike, and you're ignoring my right to strike and object.
Ms. Dineski, let me just say this. If you want to continue in this hearing.
What are you in court for if the Supreme Court, you know what that knows about these people? They always claim they got Supreme Court cases that says you don't need a driver's license to drive, a Supreme Court case that says, no judges can issue ruling, Supreme Court case that says this. I guarantee you, if I read those Supreme Court cases, I'm going to find the opinion in the order in the context of the case totally different from what they believe it says.
And not be removed from this Zoom hearing, this hearing can go without you because
No, it
it's my
can't.
under- it's
You need
my
to uphold the law.
understanding.
You took an oath to uphold the law. The
Is
law
this
says
a,
that
is this
this
a
case has no
default?
standing.
Mr. Fanta, have you filed for entry? It looks like I see an entry for default, which means, Mr. Nesky, you didn't file an answer to the complaint.
Because your first answer was stricken from the record in the last hearing that you argued against. So by law, you had to file a new answer. So if you didn't file a new answer, then yes, they can move for default judgment.
So
Yes, I did. You struck it from the record, remember?
You're only,
Illegally.
no, you're
Right. So if she struck it for the record, that means that answer, you can't, you have to file another one. You don't come back and argue that you already filed, but it was struck for the record. You got to file a new answer.
And nobody told me what the default was. I have filed repeated things and answers.
You never filed an answer.
I refiled many answers.
No, you never filed an answer to the complaint.
Yes, I did. What do you think all the things I submitted were? Those were answers. They were motions to dismiss. That was my answer. My
You
answer
did not
to
file
the
an
complaint.
answer to the complaint.
Okay, well, I'm not an attorney, so I filed.
But
I
although
filed-
you're representing yourself,
doesn't matter. My answer was a motion to dismiss. I am stating on the record that my answer to the complaint was a motion to dismiss, which is a valid answer to a case that has no standing. This case has no standing. You are hearing this case in complete absence of jurisdiction.
This
And you're going to
complaint
go
was
to prison
filed
for kidnapping my child.
May 15, 2023.
I filed multiple.
You want to know why she's acting like that? And a lot of them do that because the kid is their power play. The child is a lot of their power. When they don't have full custody or possession of the child, their power is diminished drastically and they don't have leverage now. This is why she's so in the uproar when her PPO was reversed, when the order was granted, custody was granted back to the dad. These are the reasons why. You want to know why this is true, especially in this case, because when they had supervised visits, she never showed up to any of them. So she never showed up to any of them. I thought it was all about seeing her kids. She complained that she wasn't able to see her kids for months, that her kids were being held from her. So when she had the opportunity to see her kids, she didn't want to take the opportunity because the visits were supervised. Well, if a person that really wanted to see their kids that bad, whether those visits were supervised or not would have been the last thing on their mind. The whole objective is to see the child. And this goes to show for many of them, and I know I might get some backlash for this, but they don't give a damn about those kids. They don't give a damn about those kids any more than how useful they are to them and how much they can use them as a pawn, as a tactic and a weapon against the man. You think they give a damn about them kids, but they really don't. A lot of them don't give a damn about those kids if those kids are not useful to them in their own selfish ways. They don't give a damn about them kids for real. They may pretend like they do. They may think that, oh, they're responsible for their survival and they help them survive, that they care about them kids, but they don't care. Kids to most women today in these situations are nothing more than pawns in their plots and the weapons against the man. They don't care about the kids' well-being. They don't care about how this is going to affect the kids, because most women like her and most individuals that operate like her, they only care about themselves. They come before the kids. And it may sound crazy, but just look at the actions. I don't give a damn about how you feel, or it don't sound normal, but most people like her do not give a rat's ass about their kids. It's always and will forever be about them.
Answers. I filed pleadings that were stricken illegally by you, even though I was told by your assistant that because there was already a hearing, that all I had to do was email the stuff to Andrew Fan. I have a recorded phone call of that. So you struck my answer, and now you're saying I defaulted. Sorry, that's illegal.
No, it's not illegal. it's defaulted. You see, you had an opportunity to answer the opposing attorney's motions, and you attempted to do so with construction paper and edible highlighters. So the court struck your answer. This meant that you still needed to file an answer to those motions, and you didn't. And Judge Triplett just realized that you're no longer needed here.
I'm looking for your proof of service. Looks like a proof of service was filed. Well, it needed to be filed by.
I have received no service on this case at all, on anything on this case, except for the very first summons and complaint.
So you just acknowledged receiving the complaint and summons.
The original one, and that was it. That's the only thing I've been properly served on.
Hold on.
I haven't been served on the erroneous PPO where he lied. And this picture right here, he took on a different date, and I want the timestamp on this picture where he lied.
Ms. Castro, hold on one second. I'm looking for the proof of service.
And in case you weren't aware,
what's the date?
There's been a writ of mandamus filed against this court and against you.
What date was the proof of service filed for the summons and complaint?
I just filed it a few days ago, but the actual proof of service was.
I have a document that has a proof of service that is before the date that the document was actually signed by the judge. So there's corruption and incompetence happening in this case, which is another valid reason for the case to be dismissed with prejudice in my favor. And charges need to be brought against Fanta and Nerswick for harassing and stalking me and producing fraud on the court, for perjuring themselves on the court.
But she was served May 21st, 2023 at 2 p.m.
So May 21st, 2023 at what time?
At 2 p.m.
For the
Let me guess, she's going to say the initial one and not the one she needed to respond to.
Initial proceedings. That's it.
So, Ms. Dineski, you received the summons and complaint on May 21st, 2023 at 2 p.m.
He actually stalked me.
Did you receive? But you just said
I'm answering your question. So
Ms. Castro, who is the person on there?
He followed me to my niece's school at one of her events and almost caused an accident in the parking lot with her in the car and was throwing.
Who was the person that
served her was Tony Price.
And Chuck was there stalking and harassing me.
So is Chuck Tony Price?
No, but he was there and he almost caused an accident in a school parking lot because they were stalking me. They couldn't wait.
Who was Tony Price, Ms. Dineski?
His business partner and the one who helped him kidnap my children.
Was he there at the time on
Tony? Yeah. He came into a parking lot and threw the papers at the car.
All right. And then
we were in a parking lot trying to go into a school event. And they almost hit people.
So for the record,
caused accidents in a school parking lot.
Ms. Dineski has acknowledged receiving the summons and complaint that was served on her by Tony Price, who she knows, in a parking lot on 5/21/2023 at 2 p.m.
I don't know what time it was.
Okay.
But that's the only service I've received about anything on this case at all. Everything else has been improperly served, which warrants a dismissal of this case. There's like 10 different reasons lawfully why this case needs.
Actually, no, because the process that you were just served on, that was what you needed to respond to. You admitted that you received it and you didn't respond. So technically, you have defaulted.
To be dismissed. And you're proceeding in absence of jurisdiction, which you know as a judge means you have no qualified immunity. And I'm going to sue you and assert my legal right to recourse against you criminally. And the penalty for kidnapping a child is the death penalty under color of law. And I will be seeking the death penalty or life in prison for you, Regina Triplett, along with Andrew Fanta and Charles Nerswick and everybody else involved. Stephanie Priest, Tony Priest, all of them. I'll be seeking criminal charges for kidnapping. Maybe if you guys had looked at the actual evidence.
Okay, it doesn't appear that an answer was filed in this case prior to the defendant being served How are
There
you
was what?
proceeding, Mr.
There
Fan?
was an answer filed, you said. Is that what you said?
I said there was not an answer.
There was an answer filed. You struck my answer.
Yeah,
My
nothing was
answers were
filed.
stricken. And my answer was a motion to,
If they struck your answer, that means you had to respond with a new one, goof troop. And since you didn't respond with a new one, you have failed to respond. Everything they're doing is by the law.
dismiss. And
Everything they're doing is by the law.
then at the last hearing, I motioned to dismiss verbally. So that was another time that I answered the complaint.
So there's no answer filed. So, Mr.
Yes,
Fanta,
there was an answer filed. It was a
you
motion.
may
to
proceed,
dismiss.
Ms. Fanta, on how Mr. Fanta, on how you want to, what you want
Yeah.
to the court.
Thank you, Your Honor. I would like to give the court a little bit of an overview as to what brings us and what we have tried to accomplish prior to this hearing.
Actually, I object because this needs to be dismissed immediately pursuant to Michigan law.
Continue, Mr. Fanta.
I
Yes,
object.
Your Honor, concerning the Growth Works visitations, there were
You need to
four.
either over, and Your Honor, you're not.
Keep going,
I
Mr.
was, I'm,
Fanta. Stop.
I'm objecting to proceedings. I need a law. Why you guys are proceeding in violation of my rights? Why are you proceeding?
Ms. Daneski has been removed from this meeting. She's been very disrespectful to this court. She's continuing to talk and be very disruptive to this court since the calling of this case, and refuses to allow Mr. Fanta an opportunity to speak. I muted her, my clerk muted her at least 5 or 6 times. She continues to unmute and continues to be disruptive to this court. Mr. Fanta, you may proceed.
All right, so it looks like the hearing to determine whether Lindsay Daneski will ever see her kids again will proceed, just without Lindsay. And I'll go ahead and play you Judge Triplett's ruling.
June 30th, 2023, the court ordered psychological evaluation to include testing, and that was on both parties. I ordered a mental illness assessment for plaintiff and defendant. I asked that parenting capacity be assessed for plaintiff and defendant. I asked for an evaluation on parental interference for plaintiff and defendant, as well as other factors to be considered so that a recommendation could be made. Ms. Daneski has refused to cooperate with the FAME Assessment, Mediation, and Education Department. And that report indicates that she refused, and the recommendation from FAME was to award the father sole legal as well as sole fiscal custody. Well, no, I'm sorry, that's what the current order was of this court. It says Ms. Daneski did not participate in the family assessment process before her scheduled appointment on August 28, 2023. Ms. Daneski sent an email to a FAME secretary stating, "I'm just making you aware that this agency is participating on the violation of my rights and asking why this agency is participating in the unlawful kidnapping of my children in violation of my rights under the color of law." So that's why the court ordered a psychological evaluation for both of the parents. They did do an interview on Mr. Nurswick that indicated he appeared on time for his interview, and all the other points relating in the report were satisfactory to this court, as well as the minor children being observed. I think this hearing was by Zoom, and they just made positive comments relating to the minor children interacting with Mr. Nurswick at the time of the interview. the court filing that the comments made about Mr. Nerswick were all or held Mr. Nerswick in a positive light. Fame could not, due to the Ms. Dineski not cooperating, a recommendation could not be provided to the court at this time and close the case out. So you indicated, Mr. Fanta, that supervised visitation, you would put in the order to continue parenting time with supervised visitation with Ms. Dineski.
That is correct, Judge. I think I would, concerning parenting time, I will just say supervised visitation is continue at Growth Works. And Mr. Dineski will comply with whenever those parenting time visits are established. And he accepts the fact that probably there will be future visits that might be canceled by Ms. Dineski at the last minute, but he will have the children there for the scheduled visits.
Okay, so Mr. Fanta, submit your order. Is there anything further?
Yes, Your Honor. We have one last hearing to get through, but don't worry, you're not going to have to kick Lindsay out this time because Lindsay didn't show up. It's a PPO violation hearing because despite being ordered by the court to leave her.
All right, y'all. Next time we go, I'll keep that last one queued. But yeah, man, that was a doozy right there, man. Hey, it is what it is. Fellas, I didn't even want to turn to this conversation, man, but be wise, man. Be wise. I know you live and learn, but you gotta be wise. Nobody should deal with that. No one should ever be subject to a person like that. No one. Now, I do think there's some mental health issues there, some psychiatric issues there. I do believe that there is some issues there, but there has to be a fine line between a legit mental health, psychiatric issues where you have no control over your faculties, criminally insane or however they word it, versus you know what you're doing. Okay. I believe, although you can make a case for some psychiatric mental health issues, I believe it's more manipulation, conniving, entitlement, lying, deceit, more than mental health issues. I think the mental health issues it's there used to be strict requirements before people were diagnosed with that. Like, I'm talking about severe schizophrenia, like mental ward type scenarios. Now today, the mental health issues can be just because you're depressed, or the threshold is so low. And I believe that in more cases than not, is being used as a crutch to escape accountability versus there being legit issues. In this case, although I believe there is the appearance of some, but it wasn't enough to the fact where she didn't know what she was doing. It wasn't enough to the fact where, she needed to be locked away in a mental ward. Obviously, she got granted weekend visits with the kids. I mean, once a week, supervised. And for a person to, have that much need and complaining that they wasn't able to see their kids, didn't even show up because the visits were supervised. Say you haven't seen your kids in months, but you never showed up because the visits were supervised, which goes to show that it was never about the kids. It was always about, in this situation, and you'll find these situations in many cases and not, that most people in this situation will indeed use the children as a weapon against the man. Now, it backfired in this case, and you always know what type of person you have or what type of person you dealing with when there's moments of strife, there's moments of contention, they're not getting their way. Anybody can praise you and tell you they love you when you're doing what they want, when you're being kind to them. But let's see how they act when they have to hear the word no or moments of contention. Do you have regular conversations with your significant other about, just the last week events, issues or things that you feel that each other can work on? When you bring things to their attention, do they automatically dismiss it? Do they catch an attitude with you? Do they get mad? Do they try to gaslight you and make you believe that's not what it really is when you're observing it with your own eyes? Whenever time you bring something up, do they say, well, what about this? What about, did they bring that up at the time the issue arose? Little things like that is a determining factor of who you're dealing with and the biggest indicators when things, if things go south. So this is, although it started off as a court proceeding, it took on way more different issues, but I'm glad we got to see it in real time because it actually highlights. Now, this was a white woman. Obviously, she wasn't black. This was a white woman. But it goes to show that these behaviors are not race specific. These are behaviors of the same people who all think alike. This is the norm of what society has done when they tell one side, you're the victims. There's always going to be someone there to bail you out. Just because of your gender, you don't have to be held accountable. These are the harsh realities to the point that when it's time to be held accountable, they don't know how to act. They don't know how to handle it because sadly, a lot of our worldwide sisters in the United States, in the back of their mind, they do feel like they are above reproach and that accountability but they bypass that. They don't believe that they should be 100% accountable for anything. And the sickening part is using their kids as a crutch, a pawn, a plot. When they get caught scamming and stealing out the register, loading up them Visa gift cards, they get arrested. First thing they say, I got to get my kids. They get caught trying to cash a fake check. What's the first thing they say? Oh, I got to get my kids. Or in a custody dispute, what's the first thing they say? I'm in fear for my life or my child's safety. You get what I'm saying? Like all these things, but these are never an issue when things are going good. But it goes back to the question that I would seriously challenge a person's ability to make sound decisions when they lay down and have kids with someone that they are going to be afraid of, that they don't even want their daughter around. Like these issues that they talk about, they just don't pop up out the blue. Like there's always going to be some early indicators, it never just bam, you wake up one morning and he just start turning into a tyrant. It's always going to be an occurrence of things that happen over time that we all see, but they are ignored. So stay wise, understand the court rules before you embark into these people's courtroom. And just remember, when you act pro se in your own right without the assistance of an attorney, you are expected to know the court rules just like a licensed practicing attorney. If you do not know the court rules up to that level, the chances of the case going remotely anywhere close to your way is 0 to none. Because once again, in court, 98% of court is about rules and procedure. The other 2% are the facts of the case. If you don't understand that, you are not equipped to step into these people's courtroom. Once again, all things finances, mortgage, autos, credit cards, student loans, state defenses, foreclosures, credit debt buyers, defenses, plaintiffs, lawsuits, whatever. The Supreme Elite Team University is here, well equipped to assist you in those matters. We have 2 professional lawyers that we work with, one with over 28, 29 years experience as a top regulator attorney for the SEC. The other one, 10 plus years experiences with corporate financing, graduated from Georgetown Law. The other one from the Morgan and Morgan family. We have other close-knit professionals. We are the top-notch, one-stop shop for all things pro se litigants. If you want your complaint, when filed, to mimic a top seasoned litigator from the top law firms in the world from a pro se standpoint, then you already know what you need to do. You need to reach out to the New Coach Empire, because from pro se litigants, we are the standard. We are setting the tone, and we are executing greatness right in front of your face, because with the New Coach Empire, you will and will forever be.
You're rocking with the best.
And we got case law and case outcomes to prove it. Once again, y'all, I will see you next time. Thomas Legacy 603 at gmail.com. Let's get it. This lawsuit against Credit Acceptance Corporation isn't just about one contract. It's about exposing a nationwide scheme that's been hiding in plain sight. Credit Acceptance structured my agreement to look like a simple car loan, but behind the scenes, they securitized it, retained control, and charged a 23.99% interest rate, well above Virginia's legal limit. That's not just deceptive, it's unlawful, and they're doing that in every state they operate in. If Virginia steps in this case, could trigger a wave of enforcement against lenders who use dealer advance programs to disguise true lending relationships. And if the federal government follows through, the IRS, CFPB, or SEC, then consumer lenders across the country will be forced to rethink how they structure, report, and enforce their contracts. This lawsuit demands restitution, recharacterization, and accountability. But more than that, it could set precedents, forcing leaders to respect substance over form and putting consumers back in control of their financial rights. The system's been rigged long enough. Now it is actually time to expose it accurately. And the claims that I'm raising in my lawsuit are the same claims that Credit Acceptance has settled numerous of times with investors, other consumers, or state attorney generals who actually stepped up and held them accountable. This lawsuit is the first lawsuit in the history of the Fourth Circuit and all other federal circuits where claims of this magnitude has been brought against Credit Acceptance Corporation or any other finance corporation from a consumer capacity. You normally see these lawsuits filed by attorney generals of states or the lawyers for the investors. Never have you seen these claims filed from a consumer standpoint. I've seen a lot of consumer complaints and lawsuits filed against Credit Acceptance and other finance companies, but they all have missed the mark because they are approaching it and attacking it from a consumer-like standpoint and doesn't have the mindset of a creditor or a lender to attack them on the level in which they operate. This lawsuit could actually spark a reform in consumer financing. I am one man taking on the complex system. So, it further goes to says that this is what took place, man. I signed the contract. The dealership transferred that contract to Credit Acceptance. Credit Acceptance now had the proper collateral so they can issue trust notes to the investors. The investors put the money up for my deal, for the purchase price in exchange for the contractables in which where I will be making my monthly payments. Cool. No issue with that. The thing is, and your legal department admitted that Credit Acceptance never gave me any type of funding in order to even support a contract, which is not a big deal. Rather, they got my promise to pay the security and they was able to raise the funds for the purchase. So is it that credit, and this is their own words, I'm reading from and it's filed with the SEC. So is it more that Credit Acceptance really just acted as a broker between me, the one that needed financing, and the ones who's willing to invest in my contract? So you all just kind of mainly were just the middleman to broker the deal instead of really being a lender in the traditional sense, like Credit Acceptance went into their own back pocket and put up the money. You kind of more broker the transaction. Is that more of an accurate statement? Well, I'll be damned.
Reminiscing the good old days, remembering to forget all the bad ones. I remember when college seemed so important, but is it worth it? Been wondering what truly matters to me. I know for sure it's not a fancy degree. I'd like to do what I love, but what if I'm not good enough? Split personality, sometimes sour, sometimes sweet. And M. Night Shyamalan story called Everything's Peachy. Can we just skip straight